This is Duke University.
Brief introduction about the topic matter and also kind of explain the schedule for the day. It's going to be a little bit different than the morning.
Thanks. Good afternoon, everyone. Everyone still awake? Welcome back. We'll now begin our afternoon session. Our afternoon session is divided into two parts. The first panel will focus on general patent damages, and the second panel will focus on the 25% rule. And for each one of these panels, we'll begin with individual remarks from each one of the panelists, followed by a group discussion. And I would now like to welcome Professor Artie Wright of Duke University, who will in turn introduce our distinguished panelists. Many thanks.
Thanks, Richard. So we have an exciting set of panels this afternoon. The first panel has 3 speakers on it, and I will introduce them in the order in which they're speaking. I'll just introduce them all at once so that we don't have to interrupt the flow of discussion. So Dr. Suzanne Michelle Esquire, she has a PhD as well as a law degree. So I insist on calling her doctor, is the senior patent counsel at Google, and obviously she focuses on patent policy issues there. Before joining Google, she just recently arrived at Google, she was deputy director in the Office of Policy Planning at the Federal Trade Commission, where she worked on patent policy issues. She was the principal drafter of a fabulous report that I commend to all of your attention that was published in March of 2011 that discusses in great detail questions of patent damages. It's called The Evolving IP Marketplace, and it's I just reread it yesterday and once again thought, well, this is really a great report. Before joining the FTC in 2000, Suzanne worked at the DOJ as a patent litigator. She earned her bachelor's degree with honors from Northwestern, her PhD in chemistry from Yale, and her law degree from Boalt Hall School of Law. She is a registered patent attorney, and she clerked for the Honorable former Chief Judge Paul Michel, who is no relation. Next we'll have another doctor, Dr. Stu Graham. In fact, all of our panelists are doctors, it happens. It's interesting. All have PhDs in addition to law degrees, but it's really very impressive. Dr. Stuart Graham is the chief economist at the U.S. Patent and Trademark Office. There he's the first chief economist, I should add, at the U.S. Patent and Trademark Office. So he manages the first ever Office of Chief Economists, which researches the impact of intellectual property on the economy. His research prior to coming to the Patent Office was also focused on questions of intellectual property, in fact, specifically patents and trademarks. And so he's done a lot of work. He did a lot of work prior to coming to the PTO on the economics of the patent system, on IP transactions, and on the relationship of IP to entrepreneurship. He received his PhD from the University of California, Berkeley, and also holds a law degree, an MBA, and, I didn't know this, a master's in information systems. His research has been published in a huge number of journals, both peer-reviewed and law journals. He has testified before numerous esteemed bodies, including the FTC, and has served as a scientific expert to numerous esteemed bodies as well. He is currently on leave serving as the chief economist of the USPTO. His academic post is at Georgia Tech, where he is a professor of management. And then finally, last but certainly not least, we have Dr. and Professor John Golden, who is the Loomer Professor in Law at the University of Texas School of Law. There he teaches patent law, contracts, and administrative law. And he also serves as the faculty director of the Andrew Ben White Center in Law Science and Social Policy. He has a bachelor's degree in physics and history from Harvard, a PhD in physics from Harvard, and a law degree from Harvard. After law school, John clerked for the Honorable Michael Boudin of the First Circuit, and then for Associate Justice Steve Breyer of the U.S. Supreme Court. John has written on a number of patent-related subjects, including patent damages. And prior to joining the UT School of Law, John worked as an associate in the Intellectual Property Department of Wilmer Cutler, Pickering and Hale, now known as Wilmer Hale. So I think it's fair to say that we have an incredible amount of firepower on this panel, scary amount of firepower, and therefore I will let them go at it. Suzanne, could you please begin?
Thank you, Artie. So it's great to be here, and I really want to thank the students because you've done such a wonderful job of taking care of us and getting us here and feeding us, and I really do appreciate it. I want to say I'm not at the FTC, so I'm not speaking for the FTC, although a lot of my comments are going to draw on the work that I did there. You know, I'm also not speaking for Google in any way, and probably talking with a little more of my FTC work perspective, but with a tech overlay. You're going to hear a lot about tech from me today. The panel this morning was so interesting, and it was especially interesting to me that it focused a lot on the problems of the technology industry with the patent system, since that's what I think about now. And one of the questions was, well, you know, what's the backup plan for tech now that they really essentially did not get what they originally hoped for from the AIA? One of Google's backup plan was hire me and try to get me to work on the patent system, right? But I think what that shows, and what I'm hoping you're going to see in the coming years, is a more technology industry engagement with the patent system than you might have 15 years ago. I think with the AIA, you saw that the tech companies really starting to engage for the first time, whereas for a long time it was like, you know, really the pharmaceutical industry, the biotech industry, because patents are so absolutely critical to everything they do. We're very much in there lobbying the courts, working with Congress, working at the PTO, and the tech industry, you know, patents were just something they had to live with. That's no longer an option. I think as the patent situation, as you heard this morning in the tech industry, has become so complex, so expensive for the tech industries that they really need to take a hard look at the system and start advocating for what works for them. Some of you are going to see, and we have been seeing, and I think you will continue to see, the tech industries really working for change through the courts, absolutely. And one reason why I think that is a really important way to do it is that the industries that the problems that the tech industry faces are really specific to the patent landscape in the tech industry. The fact that products are covered by thousands of patents that are sometimes really overbroad and vague and with a really low obviousness bar needs to be addressed to support innovation, but that it's also really important to address those issues in a way that doesn't undermine the biotechnology and the pharmaceutical industries and how the patent system plays out there. And whereas legislation is not a great tool for making those kinds of technology-specific distinctions within the patent system, the courts are. The courts are the place where you want to take a broad idea and apply it in a fact-specific way that can take those kinds of problems into account. I wanted to lay all of that out because I think it is absolutely where damages law needs to go, that you are going to see, for a lot of reasons, the action in the courts, and because I also, it's important to understand a lot of the problems that led to the damages debate in the legislation were very technology specific, and we need to talk about that, and we need to talk about how the courts are going to deal with that. So when the FTC started the work that culminated in the report released in 2011, which is different than the report released in 2003 that you heard about earlier. The 2003 report was a lot about patent quality. This one's a lot about patent damages and patent notice. But I wanted to give you a little sense of why an antitrust agency was dealing with the patent, this patent law, this is not antitrust law that this report is about. And well, I think one of the important things to understand is that the patent system has significant effects on competition, right? That is the point of the patent system, to provide that relief from competition, to incentivize innovation, but that the patent system can also have unwarranted and bad effects on competition. And it's not appropriate for antitrust law to address those problems. It's not a good tool. But that's not to say that there's no effect on competition. And the FTC has a mandate in its statute to study marketplaces, study competition, write reports, and advise Congress, put out reports and things like that. And that was the genesis of this kind of work. So when we started thinking about damages, and there was all this debate about what was about the legislation, let me give you a few statistics. A lot of the debate was, oh, damages are too high. No, they're not. Damages are too low. Damages are just fine. It's like, well, what's the answer? Are damages too high? Is there a problem here? In the end, you're never going to be able to answer that question, was how the FTC staff felt. It's a fact-specific question in every different single case. And so instead, what we thought to do was to think about from scratch the economic principles that you would want to apply in a rational damages system, figure out what that damages system ought to look like, and then compare it to what was going on in the courts, and look for disconnects and systemic biases that might be leading to difficulties with some of the damage awards. I think this kind of study was warranted in the sense that some of the things you're seeing, for instance, and that led to this is damages too high versus too low debate, where median damages over the past 10 or 15 years has been on the order, and this is regularized dollars, of about $4 million, right? Median damages in the past 15 years in the software world, in cases brought by non-practicing entities, it's been $140 million. Okay, in hardware, it's been $50 million. So you saw some really shockingly large awards happening in the tech industry, and even now, as maybe a lot of you know, it's really the non-practicing entities that are a problem for the tech industry. Google has had 100 patent litigations. There's probably over 50 active right now. About 2 of them have been patent trolls. It is a significant problem, continues to be a significant problem, and there was a feeling that a lot of this business model was being driven by this allure of arguably high damage awards, and then that something needed to be done about it because it was a drain of resources and bad for innovation. So why does it matter to get damages right? I have heard the argument that, look, if the patent system's good for innovation, and it is very important to have damages be high enough to protect the patent right and incentivize that innovation, isn't more reward, isn't higher damages going to get you even more innovation? And the answer is no, and for a lot of different reasons. One is that it's going to, and really importantly, you're going to end up deterring the innovation of others by just increasing their cost. You're going to increase costs to consumers. You're going to, in a lot of important ways, disrupt the allocation of resources in the way R&D is done. If we really over-reward trivial software patents through litigation, what are you going to get? You're going to get more trivial software patents, right? And people aren't going to spend their money on something more worthwhile, and you don't want that to happen. And then also I refer to the MPE patent troll problem. You really, if damages are too high, they really encourage that kind of, I'm going to buy a patent cheap speculation idea. I'm then going to assert it in a way where I can extract a lot more money than the technology is arguably worth. But what does it mean to have right compensation? I'm talking about damages that are too high or too low. That assumes that we have some right number, right? Well, and the report goes through all of the thinking on this, but it's how would the market value that invention? What would someone be willing to pay in the reasonable royalty context anyway to use that invention at a time before that implementer had sunk costs and all of that? The market that's going to, technology market that's going to value that invention is going to depend on what other alternatives are there, how much value does that invention add to the product that it's being incorporated into. And the damages, what you really want from reasonable royalty damages, where I'm focusing my remarks, is to recreate that marketplace and figure out how the market's going to value that invention. And when you have a situation where the value of the technology created is different than the value of the patent, you have disrupted the technology market, and you've created all kinds of distorted incentives, right? And you see there's a lot of conferences out there right now in the patent world about how do you value patents. And it just irks me to no end, because it's like no one ever is talking about how do you value technology, right? And when all you're doing is valuing patents, you're creating all sorts of weird distortions in the system. So it turns out the law that we have is actually a pretty good law. We have some like good basic stuff in there, and that the goal of patent damages is to give damages that are adequate to compensate the patentee for the infringement. And in the reasonable royalty context, we use the hypothetical negotiation. What would a willing licensor and a willing licensee, the patentee and the infringer, have agreed to at some farther back place in time in licensing that patent? A market-driven idea. And so that's great. So why wasn't it working? And I think these become really hard questions in what you're going to hear about for the rest of the day. The report talks about a few reasons why in some fact situations it wasn't working well in litigation. One is that in that kind of market-driven analysis, you need to understand that what the willing licensee would pay should really be a cap on what the damages ever ought to be in a reasonable royalty context. And you see courts uncomfortable with that situation. And the question they ask is, well, but what if the patent owner doesn't want to take that amount of money to license? Okay? And they talk about the counterfactual problem. We're trying to create this hypothetical world, right? Well, you know what? If the patent owner didn't want to take the maximum amount of money that the licensee was willing to pay, it must be because he had some better option, right? What's that better option? Probably making the product yourself and selling the product yourself. Well, if that's your problem as a patentee, then you should be going for lost profit damages. And there's an argument that this concern about what the patentee is willing to take, rather than what is the licensee willing to pay, it was over influencing reasonable royalty damages and the kind of evidence that was allowed to come into court and the kind of awards that we were getting. So, some of the other problems and I think they're related to this broader issue that I've identified here, is that district courts were not engaging in sufficient gatekeeping, and you're going to hear more about that, and that's about saying damages always comes in through expert witnesses, right? Damages testimony, and saying, no, that testimony doesn't make sense. It doesn't cut the bar. I'm not going to let it go to the jury. And that a lot of courts weren't doing that. And we're going to talk doing that enough. And we're going to talk a lot more about that. Another was this idea that the Georgia-Pacific factors, which were seen as a methodology for calculating the reasonable royalty damages. The Georgia-Pacific factor is a list of 14 factors. It's a very nice list. In the 70s, some judge told his law clerk, go look at all of the cases out there. They looked at everything and make me a list of all the factors anyone's ever considered in deciding damages award. I'm gonna put them in this district court opinion. And that's great. It's a helpful thing, but understand it's just a list, right? Other ideas might be important. Factors on that list may be completely irrelevant to an awful lot of cases. But what you saw was damages experts who felt like they had to march through all of those factors. If they left any out, they were subject to cross-examination, and it brought in all kinds of information that might really be irrelevant and it could be quite confusing to the jury. And so I think an an overemphasis on Georgia-Pacific factor looked like a problem too. These issues became especially difficult in the high-tech industry because, again, there you have issues of complex products covered by thousands and thousands and hundreds of thousands of patents by the time you get to a cell phone. You're in litigation for one patent. You're trying to figure out what that one patent contributes to such a complex product. You're doing it in a world where the reality is nobody licenses one patent. What you have is big operating companies with huge portfolio cross-licenses to each other. And that's what's out there is the comparable licenses. You have no transparency in the market. This isn't like buying a house where prices are recorded. Nobody knows what, it's very rare to know what anyone else pays. Those are all confidential, right? So you got to a world in the tech industry where the only known thing was that IBM licenses its entire portfolio for 1% to 5%, and that was put out there as, okay, well, this is sort of the standard licensing rate in the tech industry. And so when I'm worried about the pop-up calendar and Outlook, I'm going to apply that kind of rate. Wow, that's insane. I mean, if you ever, and then I'm going to argue about what the base should be. What am I going to apply that rate to? Outlook, Microsoft Office, the whole computer, you know. And those were the kind of debates that were going on. That if you ever, I think one of the problems with patent law in general is that we tend to really love our legal doctrines and our weeds, and we have all kinds of debates about them. And if you find yourself doing that, take a step back, explain what's happening to an intelligent person who doesn't know patent law, and say, does that make sense to you? And I posit to you that if you tell someone, I want to value the patent on the pop-up calendar for Outlook by applying a rate used by IBM for its entire portfolio and debate whether it should be applied to a computer or Microsoft Office, they're going to say that's an insane way to value that technology, right? And yet this got into district court. So what happened then, there was I'm going to have the others are going to talk about some of these Federal Circuit cases, but you saw the Lucent v. Gateway case where the Federal Circuit basically says, no, that's not a comparable license. You then have the Unilock case, Federal Circuit case, where they said the 25% rule, which you'll be hearing about, is not a good way to be calculating damages. And so we saw some improvement in the case law there. What you're going to hear from me is we threw out the worst, most crazy abuses in the system. There's a lot of work to be done, and it's really interesting to see how it's playing out.
Thanks, Suzanne. Stu.
So, thanks, Suzanne. Thanks, RT. Thanks, John. Thanks, everybody here at Duke. It's great to be here. Thanks for having me here today. I guess I should launch my slide deck. Is there a special button I should push that says show?
This is yours. Okay. Yeah, there you go.
Great. So, thanks very much. I'm guessing this is the magic wand. Be gone, American Invents Act. No, I say that in jest, and I am not here officially as a representative of the USPTO. I say that completely in jest, only because as Artie knows very well, it's very exciting around the USPTO right now. But I would describe the atmosphere as frenetic, right? There's so much that we're doing. And but it gives us an opportunity to really react in very interesting ways to this new era that we're living inside. So let me make a few general comments. As I said, I'm not here officially as a representative of the USPTO, but I do want to say a couple of things in support of the agency where I'm privileged to work, and that is that, indeed, as you heard this morning from representatives from IBM and other panelists, there are opportunities to be involved here, right? The American Invents Act, in which we are frenetically engaged in implementing, is being implemented in a way in which we are really very much interested in inviting public comment into the process in which we're engaged. And that includes from the studies to the rule packages to the other implementations. Please, keep your eye on this site. This is the implementation site. You can find here all information about the various aspects of implementation that are ongoing. There are many opportunities to be engaged, and we invite you as all as important stakeholders of this ongoing process to give the agency your the benefit of your expertise and thoughts. Okay. So with that said, as front matter, I decided to take a tack today that will allow me to do something that we oftentimes do in the social sciences, and that is to do a little bit of a discussant role on the FTC report that Suzanne just familiarized you with. I'll be rather light touch here. I don't come to bury Caesar, but I do come actually to praise him. I do think in many ways Suzanne put this report in its proper context. As an economist, an economist who cares and thinks about the patent system and how the patent system is working. I do find the report to be quite a masterful piece of work, and I would encourage those of you who are either part of this system or anticipating entering into this system to take a careful look at this, because I do think that many of the issues that the FTC raises in this report are fundamental issues that the patent system is going to be dealing with increasingly, has been dealing with for decades, and will only increasingly need to deal with as we go forward. As an economist and as the first chief economist inside the USPTO, I think my position itself is a recognition that this area of the law, the activities that you are engaging in and will engage in over your careers are only increasingly important to the competitiveness of the country, to our joint economic benefits. Economic studies, as we've seen this morning, are showing that intangible assets are now over 50% of business outputs in the United States. We don't have the luxury anymore as the overseers, as the participants in this patent system, to be content to live in the shadows. Right? We are front and center now, and we will continue to be front and center for, I suspect, the majority, if not all, of our working lives. So from that standpoint, and again, speaking with my economist hat on, I do think it's important to understand and to think critically about the role that we play and our system plays in the overall innovation system. Right? And that's why I think that this report is such a fundamentally good one, because it does lay out a convincing story of how these different pieces in the system work together. And really, they are a system. So, when we stand in front of you now and talk about the damages component, as you can see here from the executive summary, the damages component of this report is only one piece of the report. And I did like the way in which this report talked about damages and talked about the entire system as one that ought to, because as Suzanne pointed out, the basic economic principle underlying this report is, we should avoid inefficient outcomes. Right? If what we care about in society is more innovation, more effective innovation, the expenditure of resources that are efficient for all of us, then we should think about the patent system or at least have advocates for a patent system that effectuates that particular set of goals. The concern laid out in the report is a concern that in any system in which you have incentives for what the report called lottery ticket or lottery style damage awards at the end of the process means that any efficient results at the beginning of the process will be less likely to happen. So let me point out a few of these, in principle. A few of these in principle would be, so think about, the entire system that leads to the end result of a patent lawsuit, right, in which there are damages. Well, we as economists say that, in this system, we think about all those steps and we think about the various incentives along the line for those steps. Well, if damage awards are, and indeed I think there are empirical questions about how, how inflated or disproportionately inflated these damage awards are, but to the extent that they are indeed artificially inflated, particularly in the big cases, if that creates incentives for actors along the way to work against early disclosure of their patentable invention, or work against the likelihood that those entities would engage in efficient negotiation up front, right? Instead, waiting for some lottery ticket payout at the end, then as an economic matter, that might not be best for the social innovation that takes place. So this is essentially the way in which damages are presented in the report, and I do think that there's a lot in the report to credit thinking about damages in that particular way. Okay, so with that said, let me move on to a couple items. I said I wasn't here as a representative of the USPTO today per se, and none of my comments about damages or anything else should be construed as being representative of the agency. Let me just say that the FTC report itself was read and fully digested inside the agency, and indeed Undersecretary Kapos, the director of the U.S. Patent and Trademark Office, officially responded in November to the report. None of those responses dealt with the issues of damages that were brought forward in the report, largely because, due to a political comedy and also, concerns and a recognition that it is not properly the place of an agency to be advising the judiciary about what the judiciary ought or how the judiciary ought to practice. These particular issues were not dealt with. But here as a private citizen today, I can say a few things myself about some of these issues. So here's the report. It's a thick one, but that doesn't necessarily mean that that it shouldn't be read. I think it ought to be. So let me go through a few of these recommendations that came out of the report. So Suzanne actually was good enough to introduce some of these issues to us, particularly about these of lost profit damages. Let me just say, as a threshold matter, recommendation 1, you can see it here. In assessing how the market would have rewarded the invention absent infringement, courts should allow the patentee flexibility in creating the but-for world to address different losses and avoid undercompensation. Right? Patentees should not be denied an adequate opportunity to establish lost profits through application of rigid rules that do not reflect sound economic principles or imposition of evidentiary requirements beyond what is required for the court to make a reasonable approximation of the patentee's loss. My apologies, Michelle. I couldn't find a way to just shorten that in a way that captured everything. And I know you and your colleagues worked very hard on the language. I wasn't sure whether this was sort of a bone to be thrown to the patent owners, as a threshold matter, right? But I say that somewhat flippantly because nowhere else in the report that I see is there a explicit recommendation about protecting patent owners' right to have the full measure of their damages. But I do say that somewhat flippantly because it is clear in the report that it is of concern to the drafters of the report that undercompensation can be a problem too, right? And indeed they say this, even though they go to great pains to talk more about overcompensation. I think primarily, you could ask Michelle herself, but I do think, and she said this in her own comments, that that they were primarily focused on many of the issues surrounding the problems in these damages cases associated with the electronics, the complex the complex technologies that the courts have had a more difficult time with historically over their consideration of these cases. Although, as we said before, and John Golden will say a little bit more about, I think they've been getting much better at doing more recently. Okay, and certainly some of the new case law is pointing us in a better direction. Clearly this is something that one has problems coming to grips with, right? The recommendation 1. So what about recommendation 2? Courts would reject the entire market value rule as the basis for awarding a patentee lost profits based on all infringing sales, and instead require proof of the degree of consumer preference. My sense is that I would consider it to go too far to completely reject this. I mean, and maybe John will talk about this in his own comments, but there are some threshold matters associated with the entire market value rule. Maybe what from my parlance, what I think is that certainly there have been cases in which this rule has been abused, right? But on the other hand, it seems that a more careful application of the rule, right, and only being able to apply it in those cases in which indeed the component parts are complementary to each other, or are integrated wholes of one another. If that was actually applied in a way that was more stringent, it seems to me that we would be able to avoid some of these more outlandish and harsh outcomes associated with this rule. It just seems to me that fundamentally the rule itself is sound in those circumstances in which the part itself is the basis for consumer demand and indeed is the basis for the entire market value. Okay. All right. A couple other of the recommendations. Recommendation number 4. This has to do with reasonable royalties, right? Commission recommends the courts award reasonable royalty damages consistent with a hypothetical negotiation analysis, as we talked about, with a willing licensee. Concerned about punishing infringement, deterring infringement, and the counterfactual nature of the analysis or unproven lost profits may have suffered should not inflate the reasonable royalty damage award beyond what a willing licensee would have paid for a patent known to be valid and infringed. Doing so risks awarding patentees more than the economic value of their inventions compared to alternatives and creating problems of overcompensation and market distortion. This is, I think this goes to some of the fundamental natures here of how the patent system is increasingly being called on to make the kind of sophisticated economic analysis that has long been the province of, say, the antitrust arena. And I think that we'll be talking about that a little bit longer as we go forward. So, Artie, how am I doing on time?
You can take as much time as you want.
I can take as much time as I want.
Yeah.
Well, let me just put this. Yeah, there are no limits. Well, yeah, that's great. So, let me just put up some of the rest of these. I think again these recommendations with which I largely agree and I think have a lot of value. I think they take recognition of things that we increasingly, as the patent bar and the stakeholders of the patent system, are going to have to take advantage of. And I know take cognizance of, and we've been doing this now for several decades. And it's now time for the sort of the law to catch up to where we are in some sense. So. Recommendation 7, preventing damage awards based on switching costs. Recommendation 8, talking about the relationship of what's the RAND commitment inside standard setting organizations, or standard setting negotiations. RAND, for those of you who don't know, is the reasonable and non-discriminatory requirements of many standard setting organizations inside that commitment. Number 12, courts should eliminate the entire market value rule when a patented feature was the basis for consumer demand from the appropriate base. It is irrelevant and it risks injecting significant confusion. Not so sure about that one, again, as we talked about. And on number 13, courts should identify as the appropriate base that which parties would have chosen in the hypothetical negotiation as best suited for accurately valuing the invention. Practical difficulty of identifying these are much larger in the context in which there's a complex product, as Suzanne had suggested before. These products that we now deal with day in, day out, with thousands of patentable parts. I heard someone say, with some experience here, that the Intel chip itself had tens of thousands of patentable inventions embedded in it. And that's just the chip, let alone everything else, the processor, right? Let alone everything else that's going on inside the laptops that we carry around with us so nimbly every day. So, these concerns, I think, are real concerns of the tech community. We heard Bernard talk about these this morning as well. And I do think that increasingly we're going to be pulled into consideration of these particular issues. And in some sense, this allows me to cycle back a little bit to the discussions of this morning, in which there was a lot of discussion about what the tech community got or didn't get out of the American Invents Act, and in the Wayback Machine that went back to 2007, right? If we go back to 2005 or even further back to 2004. We see a list, right? If you go back all the way to 2003, 2004, the list, which include, as we saw this morning, elements of reinvigorating non-obviousness, right, or paying attention to injunctions, right. Increasingly, the courts stepped in and took care of these issues, or at least removed them from the list of patent reforms that the community largely wanted. And I think in the end, we were left with the bill that we got. It does seem clear that there was some feeling that damages provision, which really does little else than say this should be firmly in the discretion of the judicial branch, right? Which does a little bit more than that, really, has now come back to where many of the other elements of patent reform have come as well, which were elements for which the judiciary could take control and are indeed taking control increasingly. And in terms of whether they're taking that control in an effective way, I think gives John a nice leadway, and so I will turn it over to him.
Okay. All right. Well, also I'd like to thank the students who organized the symposium and invited me, and also thank the members of the panel for working with me on this as we coordinated what we're talking, and also thank the audience for coming and listening to us jabber for however long we go on. I would say about the FTC report, it is long, but they do have, as the FTC always produces this executive summary, which even if you don't want to read the entire report, you should read the executive summary. And as Stuart's presentation points out, you can find the recommendations boxed and numbered, so you can get the ultimate gist of what they're pointing at there as well. And for the students, you should know as a practice tip, if you're going to litigation, these reports from the FTC are usually nice things to cite. You do see actually courts and Supreme Court justices had known to cite them in their opinions, much better than citing, academics like me, and already tends to carry more weight, I think, with the judiciary, it seems. So they are useful to look at, to learn about not only what's going on, but can be useful in practice as well. Okay, well, I'm going to talk about what the courts have been doing, and this is probably going to be very familiar to a number of the practitioners of the audience, and I tell them, what Enrico Fermi said, as I got my PhD in physics, he would say that, it's not necessarily a bad thing to hear about a talk about something you've heard about before. And in fact, I could say in preparing this, I thought it was sort of fun to and helpful to go back and look at these Federal Circuit cases that have come out with a little more distance from them. Okay, so we're talking about damages here. We're particularly focused on reasonable royalty damages, but it's important to remember this is all part of a larger remedies regime. That we have damages courts can offer, compensatory type damages like lost profits and reasonable royalty damages. You can have enhanced damages for willful infringement up to treble damages. And then, of course, you can have injunctions, which have been a whole another big issue in the development of remedies in patent law, where we've seen the Supreme Court and eBay and the lower courts in the aftermath of that dealing with the question of when injunctions should issue, finding that they shouldn't issue as automatically or easily as they have in the past. We've recently had the Federal Circuit really turn some attention to when courts should be able to find an already adjudged infringer to be in violation of an injunction in contempt, and then the sorts of remedies you can get for that. And finally, I think the courts are moving, and I have an interest in this since I have an article coming out on it, to consider really what the scope of injunction should be. And this was also touched on in the TiVo case a bit in terms of how injunctions can and should be drafted and how far they can reach. So I think there's been a lot going on in this area of which this is a part, and obviously in order to have a regime that really works well, how these different parts work has to be somewhat coherent. Okay, well, as has been mentioned, we had an effort to try to get statutory reform of the damages regime. That failed, and what we've largely had, not unrelatedly, is essentially judicial reform, really led by a number of the judges of the Federal Circuit to try to make this regime work better. One of the really major cases here, you'll see Microsoft as a defendant in lots of the cases that have been major cases in this area. Lucent versus Microsoft is really probably the most important one. This was a case where a jury had awarded, as Brian already pointed out, about $360 million based on the date picker in Outlook. You can bring down the Outlook calendar and then select a date by picking on one of the days, the boxes in the calendar. Okay, a Lucent expert had argued that based on this date picker patent, Lucent should get 8% of the royalty based on Outlook's price. Originally, they had argued, as Suzanne adverted to, the original argument was based on the entire price of the computer. There was 1%. The court said, no, you can't go to the entire computer. So then the expert came back the next day with the royalty rate then went from 1% to 8%. So I'm not sure the number Lucent was asking for may have been exactly the same at the end of the day, conveniently, but they just sort of changed the base, increased the royalty. What you see in a lot of these cases is you see massive disagreements on the two sides over what reasonable damages are. So Microsoft had argued for damages here originally to the jury of only about $6.5 million. As you see, you have a sort of almost factor of 60 between what Microsoft thought was proper and what the jury gave. And that's one of the real problems here, is trying to figure out, what is the proper way of measuring reasonable royalty damages? What is a proper reward? It's very difficult with these multi-component products to figure out how you apportion the value. Okay. I will say one thing to keep in mind here, and why I tend not to shed too many tears for companies like Microsoft, is Microsoft had an uncontested division-wide profit margin in this area of 76.2%. And I would say, whatever is going on is you have something of a social windfall that's falling to someone in this area. No matter how brilliant you think the people at Microsoft or Google or Apple are, there are lots of brilliant people who are doing socially valuable things who aren't getting the sorts of profit margins you're seeing there. And so it's not totally surprising that they're being targeted for litigation. And to some degree, I would question, who really deserves the kinds of money that's being generated here. So anyway, all right. Okay, Chief Judge Michel wrote the opinion for the court here in Lucent. They sort of embraced, they said, the hypothetical negotiation method was okay to assess what were reasonable royalties. He said it's necessarily inexact. The Federal Circuit and the courts throughout this process have continued to reaffirm the Georgia-Pacific factors while recognizing, they've, I think, helpfully indicated they're only a list. I think, as Bernard suggested, a number of people would say they'd really like them to junk this list, even though they're trying to emphasize that it shouldn't, create some sort of straitjacket for analysis. So we're still using the Georgia-Pacific factors. On the other hand, there really has to be some attention to whether there's substantial evidence for what the expert and what the litigant is or party is asking for. The burden of proof is on the patentee, so there's a re-emphasis just on basic principles of saying you have to have some truly reasoned explanation for the amount you're coming up with. The court emphasizes also that though the lower court, the trial judge has to do gatekeeping, the parties are also responsible for raising objections. So you see both in this case and in the I4I case decided by the Federal Circuit, the court saying, look, you have to make objections, or you can't say, the district court failed to do something. You also have to make timely objections. In the I4I case, one of the things the Federal Circuit emphasized was there was a failure to call for a pre-verdict judgment as a matter of law, and that was resulting in a sort of much more difficult standard of review for Microsoft, who wanted to get rid of a $200 million judgment against them in that case. So parties are responsible as well, and that means attorneys, for really making sure that the district court judges' feet are being held to the fire in trying to improve this process. Okay, what we see in a lot of these cases is concern with prior licensing agreements, and what kinds of prior licensing agreements can you bring in, and what are they probative of. And in this case, you had, I think, about 8 different prior licensing agreements come in, and the court looked at them and said, look, a lot of these are just, they don't seem really relevant or useful for what Lucent is trying to prove. First of all, Lucent was arguing for a lump sum royalty or damages award. 4 of the agreements were running royalty agreements, and comparing those to a kind of what would be a lump sum, just a fee for licensing you get to do whatever you want with this technology, was difficult. 3 others, they said we don't, or a number of them, they said we don't even know what the content of these agreements are, what they really cover, so it's difficult to see how they're comparable. So they're just basic flaws in the kind of evidence being presented and a failure to explain how this is really probative. What the courts are cracking down on here, and the part of the fear of the entire market value rule, is just that the courts are recognizing that what a patent holder often wants to do is just get a huge number before the jury. A number, a 10-digit number, or at least a number, say, in the high sort of 9 digits, and then present themselves as, look, we got $1 billion number or whatever, and we're only asking for $100 million. We're not greedy. I think this is a basic thing that courts are reacting to. You've got to have some real justification to kind of put that number, which everyone knows can create a cognitive bias for the jury, before you can have that be in court. Okay. Then a final issue here is the court is pointing out to these concerns with proportionality and dealing with these complex multi-component products. It says, we just have a tiny feature of a much larger software program. We should expect, as a general rule, that you should have a relatively small percentage of the overall worth of the program being awarded. Okay, so that's the sort of classic case. We had some others coming after that which were just building upon and reaffirming principles here. Actually a relatively low by comparison royalty or damages amount and rescue net, only about $500,000, but a high royalty rate may have been partly what was catching the court's attention here. There you had a per curiam opinion. Here stronger even, saying that the hypothetical negotiation approach to determining reasonable royalty damages was really the way. Again, the Georgia-Pacific factors seen as something you were generally going to use, but some at least parenthetical criticism of them saying that they're unprioritized and overlapping. Okay. Again, prior licensing agreements entering there, calling for a need for explanations and factual findings as to why you're bringing in these particular licenses and how they're actually useful to determine what a royalty rate is. Unilock case has been mentioned. Again, a massive award. Again, a massive award against Microsoft. $388 million. I mean, but they had asked for $500,000. So the jury, I don't know exactly how the jury came to 388 instead of $500,000. But again, we're seeing these massive differences in what the parties are looking for, which the courts, in particular juries, have difficulty dealing with. Rejection of the 25% rule, which is going to be the focus of the next panel. In the wake of this, we've seen the district courts working on this problem at a number of different points in litigation. There are the Daubert challenges. There's always a debate in conferences about how you pronounce this. Is it Daubert, Daubert, whatever? I'll say Daubert. What Daubert challenges are, that goes to when you can get an expert in and what type of expert evidence can get in. One issue there is that district courts have great discretion in deciding on Daubert issues. And so that raises some management questions with the federal courts in terms of trying to have litigation be predictable and proceed in relatively uniform ways across the country. Also, technically, regional circuit law governs those Daubert opinions, which the district courts always say, but then they seem to always just be citing federal circuit opinions when they're actually deciding what gets in under Daubert. So it's another potentially interesting aspect of that, though, is if you did start to see real reliance on regional circuit law as opposed to federal circuit decisions. And then, as I mentioned before, there's these questions of when you have pre-verdict motions versus post-verdict motions, and the different standards of review you have there, that being highlighted by I4I versus Microsoft, where Microsoft dropped the ball a bit in failing to bring a pre-verdict JMOL. Well, what do you see the district courts doing? Because I think one thing I saw, I mean, I get a little concerned in this area is one where we're almost demanding, you could say we're demanding pseudoscience to be produced, because as I've suggested before, it's very difficult to decide how you apportion value to just a tiny component of a larger product or process. And it's not clear there's any really rigorous way to do that. I think the district court judges have been very sensitive to that. You might say overly sensitive, and then you might think they're still letting too much in. But they have, I think, shown proper concern for worrying about demanding unrealistic exactness or rigor. And it's a general issue in law that there's a sense that I'm teaching contracts, as already noted. I'm doing the remedies and damages part of contracts today, and the general principle there is you generally don't want to have to demand. There's a demand there also for specificity and lack of speculation and damages, but also a principle of law that you don't demand more than you can expect a litigant to provide as a form of proof. Obviously, if you demanded more than they could possibly provide, you're not providing any remedies at all. Another thing judges are very concerned about is overstepping their role and treading on the role of the jury. And so you do see, some might say you see over restraint by the judges and letting too much expert evidence through because they are concerned that really these are issues of weight that the jury needs to decide and deal with. Again, as I mentioned before, there is this call for a reasoned basis. As an example of this sort of reasoning, I would look at the district court opinion we saw in Lucid come out just by Marilyn Huff of the Southern District of California in November of last year. There we had use of a survey which is a new form of evidence, another form of evidence that you're now going to probably see quite commonly in patent cases when you have damages online, where they were trying to figure out, well, who cares about the date picker? Who uses this date picker? Does anyone use the date picker? Do they really feel this is important to buying Outlook? Amazingly, I thought, but it was upheld as good expert evidence. They had an expert who did a survey which found that 7% of a substantial class of buyers said, they would not have bought Outlook without this date picker. Anyway, they had the evidence in and got it before the jury, and it was found to have been credible there. So this is a new form of evidence, potentially again leading to a new form of kind of pseudoscience or check science you might worry about, but was used with effect here. We got a revised jury verdict, substantially lower, about a fifth of what it was before, $70 million. Microsoft had, sorry I didn't spell argued right, but had argued for about $2 to $5 million. So still a great disparity in what the parties were looking for. The district court reduced this to $26 million. Again, there's this call for sound economic and factual predicates, although you can worry, did the court actually enforce this stringently enough? Here, the lowering of the damages award became because what had won before the jury was an attribution of $67 of the $98 value of Microsoft Office to Outlook itself. Microsoft Office is a suite of programs that consist of Word, Outlook, Excel, and PowerPoint. I can tell you a survey, very disappointing to me as an academic, legal academic, was PowerPoint was found to be the least used part of the Microsoft Office suite. Anyway, here you see the court applying rough justice. It doesn't really have a good way to apportion value. Somewhat ironically, given the rejection of the 25% rule, it comes up with 25% as the value it apportions to Outlook, although there's a reason here. Basically, it says we have four basic components. When Microsoft sells these separately, at least according to its 2010 price list, it charges the same for them as standalone products. So we're just going to apply 25% rule here and thereby reduce this damages award to $26 million. Okay, so what we see is courts are taking a kind of rough justice approach. We do have concern with the great discretion to the district courts that it's going to be difficult, I think it's going to be very difficult to get true uniformity and predictability as to how this works. But there is greater attention to trying to assure some proportionality and fairness, trying to still ensure that there are reasonable returns for the commercializers of innovations, but also some reasonable protection or reasonable hopes for good returns for licensors or people just trying to enforce inventions. And given this rough justice, my feeling is I think what you need to try to focus on at the higher legal level is just having some good principles for how the regime should work. And I have 5 I've written about previously. Non-absolutism, which means you're going to allow for flex in the system for exceptions. Anti-discrimination, which means you don't, I have not been a great fan of simply going about kicking patent trolls or even calling non-practicing any of these patent trolls. You have to have some openness to different types of business models and approaches to commercializing invention. Devolution, which means that we're going to have a lot of these decisions decided on a case-by-case basis and at relatively lower levels where people are closer to the facts. Administrability, you need rules. It's going to have to be rough justice if courts are dealing with it. It has to be a system that, in our current world at least, where generalist judges can administer it. And then you want capacity for learning, which means that you want rules where the system can actually get better over time. It can learn about new types of evidence can use. It can learn how to use this types of survey evidence. And if you look at the first letters of these 5 principles, you'll realize who my favorite tennis player is. Point for another, so I'll stop there. Okay. I'm not sure how to close this. I'm not sure. Yeah. Yeah.
You have to rearrange them.
Yes. Yeah. I know. I made it a little tricky. It's an anagram.
Yeah, it's an
Okay.
anagram.
All right.
Thank you, John.
Okay. Right, you can, I was trying to get a screen that we could move to, so you can get something else up.
Well, let me try if I can, see if I can do that. Does any of you want to respond to one another, before I start with the questions? Is there anything burning you want to say about something? Yeah.
I just have a question, John. So how, to the extent that it was disclosed in the case that you read, how was the survey evidence brought in? What was the mechanism? What was the process by which it came in?
Well, it was through an expert report. So you had an expert who was a survey expert and was viewed, was viewed as someone who'd done lots of surveys of this type. And I mean, one issue here too, which people who are litigators are probably dealing with, is you're going to need a number of different types of experts. You're going to need an expert who's sort of more of an economic expert on damages. Then, as in this case, if you want to do a survey, you need someone who's an expert in conducting these types of surveys and how to design them, how to ask questions, what the statistical significance of the results is. So that's basically what happened. You had a separate expert, I think Mrs. Sims or something, who had conducted this survey, and part of the question was as to her competence and expertise, and then also as to the probative value of the particular survey.
Thank you.
It was done for the particular case. Actually, Microsoft had run their own survey, of which they didn't disclose the results.
Yeah, I was going to ask you,
So.
Microsoft is a counter expert.
Yes.
The 7% does seem awfully high. So,
I mean, it was.
They have their own survey.
Yeah, but apparently their survey only they had done the survey. They didn't actually. Another contested issue was whether it should get into evidence that they had actually conducted a survey that had gotten in because they were challenging the other survey. Which it never got in what actually the result of that was. Apparently it didn't turn out too well. I mean, one could imagine a problem with this survey is whenever you pick out a particular item, it suddenly becomes more salient to the people who you're talking about. So I would imagine it's very difficult to correct for the kind of biases you create based on that. And Microsoft may have run into that problem with their own survey, even though they were probably designing it to try, what you would think were designing to get as low a number as
as that salience bias would be the first thing a survey expert would
Right.
think of. So it doesn't seem like a very good survey if it was designed to just address that specific question. But, one question I had that obviously comes up in all of your talks is, a lot of this has to do with the quality, a lot of the questions and the problems have to do with the quality of the evidence that gets before the jury, which places a lot of weight upon, if there is a jury trial, which there is in most cases, a weight upon what the judge is doing through Daubert and through other mechanisms. Do we see, so John, you talked about evidence of learning in the system. Is there learning in this area like there has been, or has there been learning, for example, in other areas where problems of complex scientific evidence are at issue? And do you think that kind of learning will also occur here? So because we've had a long history of scientific evidence being something that's complex for the judicial system to deal with. Has there been evidence of learning in other contexts, and do we expect there to be evidence of learning in this context?
Okay. Yeah, I'm
And that's
not
really for all of you guys.
Right. I'm not the best expert on whether there's evidence of learning in other contexts, but I do think, it's something where there have been efforts in other contexts, say, to educate judges and at their conferences or whatnot, have them learn about particular technologies or particular types of evidence. As we've had interchanges before about antitrust law, and antitrust law is often viewed as an area where the courts have become more educated about the sorts of economic principles and kinds of evidence going before them. Of course, they're helped there by having, or some might feel they're hurt, but we'll just say they're helped for the moment by having an expert agency, actually two expert agencies, the FTC and the DOJ, the antitrust division of the DOJ, which are producing not only their own reports, but also guidelines and also intervening in cases to help provide information to the courts. And as I suggested before, this is why reports like the FTC's reports on patent law, I think, become important and are cited by the judges, because the judges generally would like to be better placed to help digest this evidence than they feel now. So I think you're likely to see some learning over time. I do think there is a role that agencies like the FTC, perhaps the PTO, if it were given a greater role here, can play in helping to educate the sort of system we have in place now. But it isn't easy.
Yeah, just as a general principle, I think that anywhere we look in the in the history of how how the courts have reacted to changing circumstances has been sort of iterative learning over time. I mean, there's some obvious examples where that doesn't play out, but I don't see any evidence here that it is not continuing apace in the patent area as well. I mean, look, there's a lot of focus now. I actually I heard Judge Lynn recently responding to a question in which he was asked, why is it that the Supreme Court is taking all these patent cases all of a sudden? And his response was, hey, look, this is an incredibly valuable, important area. And it's in some sense, I won't put words in his mouth, but my own words of this is that there are a lot more demands for the system and the institutions to catch up with reality, and indeed, I do see that continuing along the lines of the recent case law developments that we've had, and I can't imagine that it's not going to continue.
I'll be a little less optimistic about that. But hopeful in that there have been steps in the right direction. And I'm going to talk about what I've sometimes called the do loop problem. It's sort of a programming term where you end up in an infinite do loop and you keep going round and round. And that is when you look at the damages case law over the past however many years. And when I've been on panels with district court judges who did not take kindly to the FTC report, what you hear from district court judges a lot is, look, I got to decide the case in front of me. I'm really, thank you, FTC, for all your really nice economic theory, but you know what? I got these two litigants, they're putting this evidence in front of me, and that's what I got to decide it on. And having an academic debate about what the perfect analysis would have been doesn't really do me anything, because no one's given me that evidence anyway, right? I just got to do what's in front of me. And that's a really important point, that's all that any court can do. On the other hand, what those litigants are putting in front of that judge is very much driven by the case law. And in damages, there's a real practical problem with litigating damages, right? You give it, as a defendant or even a patentee, a little bit of time at the end of a case where you're really putting all your firepower into showing liability. As a defendant, you don't want to spend a lot of time saying, I don't infringe your stupid patent, but if I did, I owe you like $100, right? You don't want to spend a lot of time on damages because it looks like you're admitting guilt, and so they don't, and really a lot of litigants do a pretty bad job. But again, they're very much reacting to what the case law tells them to do, the judges are to say, and so you need some kind of shock to the system. In a federal circuit opinion, a Supreme Court opinion can provide some of that shock to the system to say, okay, no more 25% rule, or no more saying that all IT licenses are 1%, no matter what. That's helpful, but I think for the really hard questions that we don't have any answers to right now about how you value that one patent in the huge complex product, I'm not sure what mechanism is going to drive the law in that direction.
So I'm going to take you up on that, Suzanne. So in the FTC report, you do employ all this very nice hypothetical or an economic theory, in particular the theory about the hypothetical negotiation. And one could argue, and people have argued, that the hypothetical negotiation is too hypothetical to really produce good evidence that yes, it's a very abstract, a good construct in an abstract way, but in terms of trying to apply real evidence, real world evidence to a hypothetical negotiation, which never occurred and neither party may have wanted to occur for a large variety of reasons, it's very hard for judges or anyone to apply that abstract construct. And one of the reasons that they might focus on, as you suggested, they unhelpfully focus on sometimes the fact that the licensor might not have been willing to take what the licensee wanted, is that they do think of it not simply as a hypothetical negotiation, but also as a property right of a sort that doesn't have to be licensed.
Right.
So I guess those are two questions, and all of you can answer both. And to some extent, they're two separate questions.
So the difficulty of the hypothetical negotiation, trying to put those parties back in time and assuming that people who have now just tooth and nail litigated in some sort of scorched earth situation would have liked each other and gotten along and entered a license, right? It's really hard to do that. And so the court is essentially looking to comparable licenses and all of that to draw on something. I would like to see us eventually develop economic theories that would be workable for expert witnesses and getting testimony in that looked more at the incremental value that the technology adds to the product. I think there's a hesitancy to do that because a lot of times the answer is almost nothing, right? So that you don't want patentees to do that, but in these complicated products, that is probably the reality. But when you have a product, when you have that many patents in the world, probably the right answer is a lot of them are worth almost nothing. Another way to think about it would be looking at the alternatives. And one alternative is to leave that patented feature off your product. Another might be, well, if I didn't do the circuit the way covered in the patent, I could have done it this other way for 1 cent more per unit, so I would have never paid more than 1 cent more per unit. And so my point is, I think the more we focus on the technology instead of all of this other stuff, maybe we can get to a better, more rational place.
Yeah.
And would that involve maybe more engineering testimony than economic testimony?
That's a good question. I sort of would love to see the patent community and the economics community, the expert damages community really start engaging these issues in a more deep and meaningful way. Because I don't know all the answers to those kinds of questions.
So, it does seem to me that, and the FTC report does point this out, that, that this probably is the appropriate way to think about it, right? The appropriate way to think about the problem is, what would two, rational, profit maximizing agents have decided at the point at which the infringement was just beginning in some sense. You point out that this is an impossibility. I think it's an impossibility for many more reasons than the ones that we've articulated today. Not the least of which is that the hypothetical itself is an impossibility because it requires us to take account of all the uncertainties that would be in the system, except for one of the most fundamental uncertainties, which is the validity infringement of the patent itself, right? Which is not to be an uncertainty under this particular hypothetical. So it is indeed a very strange hypothetical. I do think it would be useful to think about these issues in more depth, because one wonders if the system, again, the patent system is ultimately a competition system. Does the future of the patent law and the institutions that support the system of patent law start to look more like the competition system, the system under which we live with the DOJ and the FTC, and what set of institutions, if that's the answer, need to be developed to support that. Those are serious, fundamental, and interesting, far-ranging questions.
So do you think the PTO should have its own guidelines for judges? You suggested earlier you didn't think the PTO should be advising the judiciary.
I couldn't possibly comment upon that.
Okay. I suppose I knew I was putting you on the spot. No comment. John.
Right. Yeah, well, in terms of guidelines for judges, I mean, I do know, Peter Manel at UC Berkeley has put together this patent case management guide, and that grew out of efforts to help in conferences, educational conferences for judges. So I think that those sort of guidelines and guidance can be useful. Of course, the Northern District of California's rules have worked as guidelines for many other courts. Even if they don't adopt patent rules themselves, they might use those as guidance or a reference point for the procedures they adopt in particular cases. So there's capacity for learning that way. I will say, in terms of, just to follow up a little more on the capacity for learning, I mean, I think someone had mentioned the Supreme Court, I think Stewart, and I actually reading the I don't know what other people's reactions were, but reading the transcript for the Prometheus versus Mayo oral argument, I was happy to see that at least it seemed the court was getting a little more sophisticated and thoughtful in the way they were dealing with this. I'm not so optimistic that the result of what they produce is necessarily going to be that much better. And even my own justice had, as notably Justice Breyer had noted that maybe his LabCorp opinion wasn't as well thought out or put together as he seemed to think at the time. He criticized it in the oral argument, was very notable. So that did show some capacity for learning at the very highest level of the judiciary about the patent system and how it operates. I think in terms of this question of where we're going with damages and what we can get out of them, I think Suzanne suggests, well, maybe these are, in many cases, when you look at the incremental value, it's almost zero. I mean, that's part of the risk in the system, though, is when you try to, for me, I think that part of the risk in when you try to subdivide these products that really can't be divided up, is it can create this bias in the other direction, which is toward too low a value. And then if you're looking at design arounds which were never implemented, you can get a kind of hindsight bias or a possibility for strategic behavior on the other end, where people, oh yeah, now we could have implemented this in another way much more cheaply. And I think there is reason to have a fairly robust, try to maintain, while having a system that isn't out of control in terms of damages, still have a robust damages regime, which will also provide incentives for firms to try to do clearance and do due diligence beforehand, or allow for, try to help develop systems where we can have patent licensing, just as you have sort of copyright clearance networks. It's difficult to see exactly how we get there from here, but trying to get there without eviscerating the damages regime, I think, is important. I had a student in LLM who was writing about the Chinese patent system, and there was a surprising amount, at least in this account, I can't say, she was citing all these sources in Mandarin, so I couldn't really check what she was doing. It could have been all made up.
That's a good tip for students.
But there seemed to be actually a surprising amount of patent litigation there, but the damages are just ridiculously low for the most part, in part because of the restrictions on discovery, so it's very difficult to prove damages in China, and it means that the rights are often relatively meaningless and worthless. So we have to try to figure out some path to have a reasonableness and fairness on all sides.
Yeah, can I ask something? Because I'm going to go like really high level academic here. So that's a really interesting comment and an important one. And I want to make a connection between that and obviousness standards. in that I think you can read a strain in some of the older Federal Circuit attitudes, and I'm thinking about Judge Newman here, and there's a quote from Judge Rich that we in the report saying the great thing about the patent system is the market values your patent, and like maybe we gave you a patent that nobody wants, that's not really a problem for the patent system because the market's going to value it at zero. And I have this theory that this attitude that it's okay to give out a lot of patents, some of which are narrow and maybe not worth very much, is not really a problem because they're not worth much anyway. So let's have a low obviousness standard. Let's allow narrow patents, like, and fill in every little space, you know, effectively a 102 standard without much 103. Thrown in there, and that's not a big deal, right, because we're not giving you much. The reality is that when you have that, you have those patent thickets, and companies have to make, we want companies to make products, right, in the face of those thickets. Companies end up responding by just like, well, what the heck, I'm going to make my products anyway and worry about it later. When someone comes after me, because maybe no one ever will. A lot of these patents are defensive, and you get you get a lot of sunk costs by operating companies. You get products out there, and then this trivial patent comes at you, which and tries to extract rents out of your product. This patent that you didn't really ever find in the first place. It overblows the value of that patent. That situation of extracting the rent after the sunk costs and the products out on the market inflates the value of that patent compared to what the real technological contribution was. And so I raise this not as a way to attack damages, but as a way to say everything's interrelated in the patent system. It's like a balloon where you squeeze in one place and it expands somewhere else. That really, if we want meaningful damages, we also have to have meaningful patentability standards.
So I'm glad you brought that up, because the first part of the FTC report does talk about notice concerns, and then of course the 2003 report talked about quality concerns more generally, and so I think one of the points in the report that is worth emphasizing, and the question is how we get there, is how do we have a manageable number of patents that can be licensed ex ante, because ex ante you would be licensing for the price of the patent, or the value of the patent relative to the best alternative. That's all you license for, and that's exactly what we want. So how do we get from our system, where a lot of this quote-unquote licensing is done ex post, to the report's emphasis, and many scholars' emphasis on the idea of technology markets where there's ex ante licensing? You know, I'll put in a plug for the PTO and say that we did, or they did, I used to be there, they did put out some guidelines that I think will help a little bit with notice. But what else needs to be done? You know, is, for example, here's a question. Is the KSR standard helping with obviousness? Anyone thoughts on
Without, yeah, I'll let the other people talk about KSR, but let me go to your point. I mean, in terms of ex ante licensing, you asked, you know, how do we do it if there's so many patents?
Right.
I'm not going to deal with the numbers issue. I mean, the numbers are what they are. Things can be done about it, and I'll let Suzanne and others talk about that. But one thing that we can do is ensure that when we do have the property right, that the patent office has done the most socially the optimal social job of getting it right. Okay, and that this thing, that we're putting out into the world is such that it is a high quality, timely property right. High quality means well described and comports with the law. Timely means is that it doesn't create unnecessary uncertainty for everyone who's trying to innovate or invest in the technology space in which this application is pending. So from that standpoint, I do believe that that many of the initiatives that Artie knows about. She was in the office helping to make sure that they saw the light of day. Many of the initiatives on new 112 guidelines, on fast track authority, and other elements that are being implemented administratively inside the office, but also, frankly, the elements of the American Invents Act that were spoken of this morning. What has been described as a gentleman's agreement over the next few years to get more resources into the patent office, which we're zeroing in now on under 650,000 patent applications in the backlog, which when Kapos came into office, it was well over 700,000. The office is making strides on beating down that substantial backlog. Again, as my talk made clear, we live in this system, and indeed, in this balloon metaphor, you squeeze one place, and things happen. The patent office itself is such an important part of that system in setting up the opportunities in which this ex-ante licensing can occur. I just point to it as a really important component before my colleagues talk about KSR.
Anyone want to take up the KSR bait, or you want to leave it? Let sleeping dogs lie.
Couple of things, and again, I want to make specific on a lot of what I'm talking about is the problems of the tech industry, and it really all of these issues play out so differently in other industries, as the damages analysis, especially the KSR analysis. My sense from people is like, yeah, KSR is helping. There's a whole world of bad software patents out there besides that. But I still question whether we're at, for some industries, not every industry, but for some industries at the socially optimal level of patenting, and it's hard for me to see how we could be, given the numbers and the still minor incremental steps that it takes to get a patent in hardware and software.
I mean, I'd say with regard to KSR, my sense is it has made some difference. I've had some students who've written sort of somewhat empirical papers looking at what it's had, what had been the effect on litigation results, and you've seen more patents being found invalid, particularly in kind of software business method types areas. But in line with Suzanne's comments, I don't think KSR is only going to deal with this sort of gigantic mass of patents, because it's not a very great tool for examiners to use to try to control what's entering into the system. So it's more likely, again, to be something that helps deal with some of the more egregious cases. And also related to Suzanne's comments, I think part of what at least many academics feel when they look at what the Federal Circuit has done, at least those who just think the Federal Circuit has been wildly pro-patent across the board, but my tendency, with line with some others, is to feel like, well, what the Federal Circuit did is they really did take a fairly relaxed view toward patentability when they came in. But at least in certain respects, they've been had this model of, many patents, but a relatively narrow scope, which is carried out most obviously in kind of the biotech sort of space. But we haven't had that sort of control for narrow scope very well at all in software business methods, and that's led to the sort of balance the Federal Circuit was trying to strike, it seems, being totally out of whack.
Yeah.
And I think there you could have, my sense is the USPTO, if it really were given the authority by the courts, if not the Congress directly, to really take a strict view of the breadth that was proper for these types of patent applications coming in, and the clarity they could demand. And the PTO, I think, has taken a view that their definiteness standard can be different from the court's definiteness standard. They can really do some work there. When I was in Munich once, I actually went to an opposition proceeding there, and it was about validity issues, but the entire morning, I have to confess, I only stayed for the morning and then went to some art museum. People were surprised. It's a public proceeding. I showed up, and no one had ever from the public ever shows up at these proceedings. So there was a lot of question of who are you? Are you some sort of industrial spy or something? But what the entire morning was devoted to was really just trying to nail down the scope of the claims and what could be a proper scope for the claims given the nature of the disclosure. And I was very impressed by that compared to the interchanges I had had with the USPTO. Where, of course, when I was trying to help get a patent, I was quite happy to have the examiner let all this stuff go through, but I always felt they really could be doing much more, and I think the EPO did impress me in the attention they were giving to that issue.
Albeit in opposition.
Albeit in opposition.
You haven't seen a post-grant review yet.
But yeah.
Right, exactly.
But, you know, it just impressed me, it convinced me that an administrative body can do that kind of work.
So I think we have about 17, 18 minutes left, and probably the best thing to do at this stage is open it to the audience. I hope our panel, you know, I'm sure will be excited to answer your questions, and as you know, they're not shy about their opinions, so please ask. Otherwise, I can continue for a long time. But if there's, yeah.
So from the damage perspective, after we've seen a number of cases that in the federal circuit that show that the federal circuit is more willing to sort of limit the type of evidence that can be used to show, you know, large damage. I want to know, has there been any evidence that the district courts are willing to do that on the front end? Because the sense I get from talking to judges is that they've always known this evidence wasn't that great, but they want to let it go. And at the very worst, they feel like they can play games on the back end with JMLs and, you know, post-jury verdicts, but they don't want to dalbere it, because once they do that, that can't be changed. They have to go back to a new trial.
Right. Yeah, well, I mean, I think as I sort of suggested, the district court judges, although they're looking at this more carefully, are generally seeming to let things get through. They don't want to shut the entire case down. And what we've also seen, it was something that, of course, Judge Rader did when he was sitting by designation in the Cornell case, is when they've decided something is inadmissible, they've allowed people to go back and revise, which I think, when I was at a conference recently in San Diego where you had a number of judges there from the Southern District of California, as well as Judge Rader on the panel, I mean, I think many of the judges feel partly because they realize they are trying to be stricter in this area than they have been, they also are reluctant to shut people down even though they haven't, you know, gotten it right the first time. Now, one might, depending on your point of view, I mean, one might hope that they'll become more willing to do that over time once it becomes clear what type of evidence they believe is needed, what type of explanations you need to provide in order to get evidence before the jury. And, you know, they have been throwing out parts of the evidence. They've been saying, you know, these licenses you can't bring in. So you do see them willing to throw out parts of the case. But you're right that they're very reluctant to throw it all out. That's certainly true.
You know, if I could just say, did you have a comment?
No, you go ahead.
Yep. I mean, it is a very strange thing that we talk about using these cases as the measure of adequate compensation. And I say that because I think that anyone who's ever studied the kind of cases that get all the way to a damages award are probably, they are selected sample and probably, and possibly completely unrepresentative of everything else going on in the world, right? The reason why they're there is because they're unrepresentative, right? They didn't end in a settlement. They didn't efficiently settle, which may tell us something about them in the first place. The extent to which we use these cases as the basis for the evidence that we collect on how things are going and try to use that evidence to re-import into our understanding of how the hypothetical negotiation might have gone, et cetera, et cetera. it is it's an exercise fraught in danger.
Yeah, the selection bias issues are just, as an economist would say, just so enormous that one mind reels. Actually, I realize that in theory, are we supposed to end at 3:30 or 3:15?
Yes, we should, in the interest of kind of staying on schedule, I hate to.
I
say
apologize,
that.
it was my fault, I thought we were ending at 3:30.
We should go ahead and take a break. We can take a 10-minute break and then resume.
Suzanne, I think you had one thing she wanted to say.
Oh, no, I was just gonna say I'd love to hear the answer to that from the next panel, who has no answer. So, what I've been hearing, from people in that world is that it's really variable and kind of chaotic out there in terms of like what's your particular district court judge gonna let in and not. And people are really feeling their way right now, but it'll be great to hear about that.
So the next panel has their work cut out for them. I would like to really thank our panelists who did such an excellent job. And I guess a 10-minute break, is that?
Yes.
But
Yeah.
someday we'll get you out.
From the originator of the 25% rule, as I understand it, Rob Goldscheider. He's going to begin with a few comments about how he got this idea started, and I'll introduce him, and then Roy Epstein, who will respond, and Mr. Goldscheider and Dr. Epstein will kind of have a little bit of an exchange, and then Dr. Liu will do a presentation, and after that point, we'll have general questions, I think. I'll have a couple of questions probably, and then we'll have questions from the audience. So let me just go ahead and introduce all the folks who are going to be talking. As I said, I think Mr. Goldscheider is going to speak for about 5 or 10 minutes to introduce the genesis of the 25% rule. Dr. Epstein is going to respond. Mr. Goldscheider is probably going to say something more, and then Dr. Liu will speak. So Robert Goldscheider is an attorney, and he's a pioneer in the area of technology management consulting. He heads the International Licensing Network that was formed in 1975. He's the author of 2 treatises on licensing issues, and he's been very active in the society I'm sure many of you are familiar with, the Licensing Executive Society, or LES, since 1967. As I've already mentioned, he's very well known for the 25% rule, which I suspect you know about already, but just to reiterate, the idea that a licensee would pay 25% of profits as a reasonable royalty, and he'll talk more about that during his brief introduction. Dr. Epstein is an adjunct professor of finance at Boston College. He has more than 20 years of experience as an economics expert in complex litigation, specializing in financial models of damages, antitrust analysis, and intellectual property damages, obviously squarely what we're talking about. Dr. Epstein has also published and lectured extensively on patent damages, including on analysis of the Georgia-Pacific factors, lost profits, and price erosion, and he holds a PhD in economics from Yale University. And finally, Dr. Jack Liu is a senior economist and director of economic analysis at the Applied Economics Consulting Group. He provides economic and financial analysis for business transactions, strategic planning, and litigation support. His expertise includes business valuation, competitive analysis, intellectual property rights, global investment risk, and quantitative analysis, so he's obviously got a wide portfolio. He conducts patent portfolio valuation, research in patent portfolio valuation as well. Prior to joining Applied Economics, Dr. Liu conducted research in various universities and institutions. He received his Bachelor's of Science in Electrical Engineering and Master's in Technology Management, studied economic policy, and got his PhD from the LBJ School of Public Affairs at UT Austin, where he is awarded the Professional Development Award, the David Burton Fellowship, and the Suzanne Haddon Dissertation Fellowship, and the Robert Strauss Fellowship. And he's also a member of the Licensing Executive Society, as well as many other esteemed organizations. So once again, we have a very, very distinguished panel before us, and I really look forward to their comments. So, Mr. Goldschneider?
I apologize for the change in the schedule, which I requested the chairman to make at lunch today, because I just learned today of a new article that my colleague, Dr. Epstein, has written about my favorite subject, and I have just scanned it. So I felt that it would be helpful, and he was scheduled to go first. I just thought it would be helpful if I would give you a brief introduction to what the 25% rule really is, since I'm being credited for the origination of this cultural situation, which is really not a rule, it's not a law, it's not been passed by any legislature. It is however, it is something which is meaningful to an awful lot of people, and I'm going to tell you why. Firstly, I'm here as a representative of myself, of course, but as a very active and the longest single member of the Licensing Executive Society, because this rule is a creature that was germinated in that environment. One of the other pioneers was the senior partner of the first speaker who harangued you this morning in a charming way, I thought, Marcus Finnegan. When I joined the society, I joined it in the third year because my senior partner wanted to be one of the 10 charter members, and he said, even though you're more involved with licensing than I am, I'm senior to you, so I'm going. You're not going this year. I went the third year. He died 25 years ago, so I think I won anyway. But I was in at the beginning of this wonderful society, which now numbers some 16,000 members around the world. It's doing something very important just this week in Geneva. It's integrating itself into the leading European economic organizations and bringing the whole technology management question to the forefront on a worldwide diplomatic basis. And I'm proud to say that that's being done by the current president of LES International, which is the governing body, and he's a protege of mine, Jim Malachowski, a brilliant young man. The 25% rule was not originated by me, as Dr. Epstein mentions in his article. It was discovered by me merely by examination of something I was given as an assignment. I'm a lawyer whose main occupation has been A, negotiating, B, acting as an appraiser of technology, and C, a writer of books, because I've enjoyed recording what I'm doing, and I just brought this one with me, which just came out. This is volume 2 of something which happens to have the Georgia-Pacific factors in it, and I want to read one of those things to you. But I discovered this, and if you've read the first of the articles that I wrote following the Unilock case, I think before I get into that, I'm going to tell you two things. Firstly, telling you that this is in the LES context, I'm reminded by a very famous introductory remark by Dudley Smith, who was the founder of LES. He was asked to get up and deliver a speech, and he said, I feel like a man who just inherited a harem. I know exactly what to do, but I don't know where to start. Well, I'm not quite sure where to start here either. But what I do want to say is that I was given this assignment to take over a portfolio of existing patents, of existing technology license agreements. They call them technical assistance agreements, because they combine patents, trade secrets, know-how, and I think that there is a difference between the two, copyrights and trademarks. And the administration of these licensing agreements was a very definite portion of their value. This was an ongoing value that the licensor, Philco, was giving to its 23 licensees around the world. And I noticed this was, I saw something that was in existence already. I was asked to take care of it, make certain that it continued to operate smoothly. If we knew of anything that we might add to it as an improvement, to do that, because Philco was very anxious to help its people. They had marvelous relationships. And so I got to know a lot about this business. And I noticed something. I noticed that almost all the licensees were earning about the same level, and Philco was the third largest company in its business. Fourth largest company, excuse me, was General Electric, RCA, which you may remember, I don't know, and the Dutch Philips company, which is still in existence. Philco was bought by Ford in the mid-60s, but it was one of the leading manufacturers of radios and televisions. Then it bought the Bendix washing machine company, and it also had refrigerators, and headquartered in Philadelphia. But they limited their main business to the United States and Canada, and outside it was all licensing. But these were very, as I say, profitable licenses, and they yielded a lot of cash flow, and they bought their French licensee and their Italian licensee as a result of that. And then the Italian licensee became the largest manufacturer of refrigerators in Europe. So this was a really successful thing. And I noticed that the licensees were earning about 20% pre-tax profit. This is what I remember it was. This is not, as I say, a statute, so that a lot of the terms have changed over the years, because we're talking about something that happened over 45 years ago. I graduated from law school before your parents probably got married. So I'm a relic of a different age. You notice the lovely electronic aids I'm providing you, because I'm a 20th century person and I don't do these things. But I do negotiate. And negotiation is at the heart of what we're talking about here. And the negotiations I really care about are the ones that are successful. I've testified about 50 times as an expert witness because of the Georgia-Pacific case. But I have negotiated several hundred agreements, and many of them are still alive. And we use many of the mechanisms that are being criticized by Dr. Epstein and others as being part of junk science. But these agreements live. People are making money from them. They're perfectly happy with them. They were framed in such a way that if they were unhappy, they would speak up and make some adjustments so that the thing would continue to be a win-win situation. And that is the essence of this. This is one reason I'm fighting to keep this alive, because this is a cultural phenomenon of the way in which people behave in licensing. There's a key word to describe all of this. It's altruistic. Successful people in licensing aren't just thinking about increasing their money. They're thinking about improving the relationship. It's a back and forth sort of thing. As I say, there is no statutory expression of the thing. It's been written about by different people. I have used different terms over the years as I've written about it. There have been certain criticisms of it to indicate certain differences that are maybe inconsistencies. All of those things can be cleared out because the basic heart of this creature is pure, and it works very well. And that's one of the things that I hope that you can take with you. The Georgia-Pacific case is something that you hear about all the time. Do you know the concept of how the thing worked? This was a case in the District Court of New York, the Southern District of New York, tried before an old trial judge who died at the end of the trial. And his close friend read the record and decided he wanted to do something to resurrect or keep alive the name of his recently deceased colleague. And he wrote that opinion. And in the opinion, sort of by the way, he lists 15 factors that he thought were helpful. And it was sort of tossed into it. If you look at this little skinny agreement in the Federal Reporter, or the federal supplement, I might add, you just wouldn't think anything special about it, and it's an enormous thing. Everybody loves the Georgia-Pacific case. Nobody criticizes it. As a matter of fact, in the decision in the Unilock case, Judge Lynn, by the way, I admire his decision tremendously. It was an excellent decision, and I recommended that you all read it. But he says the court's rejection of the 25% rule of thumb, and notice I say 25% rule of thumb, not the 25% rule. A lot of people have said, ho, ho, the 25% rule is dead. Let's go dance around the fireplace or something like that. But that is not what the judge said. The judge, in every one of his pejorative statements, refers specifically to the 25% rule. And I say that should be dead, because that is a wooden mechanism that was a shortcut by lazy people to avoid the real work you've got to do if you're going to negotiate an agreement properly. So he said the court's rejection of the 25% rule of thumb is not intended to limit the application of the Georgia-Pacific factors. Well, you should know the Georgia-Pacific factors. The 14th says that you can use experts, and the 15th describes the hypothetical negotiation. But the 13th was put in there because already for about 15 years, when this thing came out, when that decision was decided in 1970, we were working with something which the judge describes as number 13, the portion of the realizable profit that should be credited to the invention as distinguished from non-patented elements, the manufacturing process, business risks, or significant features or improvements added by the infringer. That was taken from what that judge must have learned about what we were doing, because that's still what the classic 25% rule is that I'm here to defend. I would say that the Licensing Executive Society is one of the most lively, enjoyable organizations you can think of. I've written almost all my things for them. Many of my dearest friends belong to it. And if you're thinking of something to join when you get out, yes, there's the American Patent Law Association. There are, of course, the bar associations. But if you want to be at the heart of technology transfer, this is where the act goes. And we're now a big league society. I think I'm going to end now just so that you understand where I come from and understand that I have written a second article which has been handed to our friends here at Duke. It's going to be the lead article in Les Nouvelles, which, in the next issue coming out in March, which takes us one step further, takes into account some of the criticisms that has been made. Not Dr. Epstein, I haven't seen his. I think his is better than the criticisms that I've seen. It's more to the point, and there's some very good things in what he writes. But the article should bring you up to date, and if anybody has any comments about this, or law firms you're working for or hoping to work for have any comments about this, don't hesitate to get in touch with me. And you can do that by calling the office or writing to the office of the LES in Washington, or it's not Washington, it's actually Arlington. I guess it's Arlington, Virginia, Alexandria, Virginia, and they know where to find me. So with that, I'll sit down for a while, learn something from Roy Epstein, and then hopefully have something to add to that. And then Jack Lew will speak to you, and he has something which is very, very interesting to me, because we've got to modernize the 25% rule. I'm aware of the fact that it's sort of obsolete in some ways, but the example I use, and funnily enough, there was an article in the New York Times a week after I wrote it, is the old Beetle Volkswagen. It didn't have all the modern features such as power brakes and air conditioning and a lot of the things that a modern car has. Didn't even have seat belts. but nobody who drove them in the late 60s criticizes them today, because they were beautifully made with excellent parts and marvelous engineering, and they are revered. The new one, which comes out, looks like it, is up to date, and that's fine. We can make the 25% rule that good if we marry it to the information that a man like Jack Lew and others of you who are highly skilled in the internet and the other methodologies, to gather all the necessary information that is described in Judge Lynn's opinion, and other people feel the classic rule needs a lot of information to put on the skeleton of the basic rule which stands. And so the modernization of this will use the skills of someone like Jack, and he'll talk to you about that. I'm not finished, but I'm going to sit down for a while. Thank you.
Dr. Epstein, and then Mr. Goldschneider will have a response.
Well, hello, everybody. Glad to be here. I'm glad to have been invited, and I'm looking forward to explaining the 25% rule, I guess, from my point of view. Let me step back for 1 second. I'm not a lawyer. I'm an economist by training, but I've written a lot about the application of economics to law, and I work with lawyers a lot, so I'm in this kind of middle zone of talking to both groups of people. I think that there is an enormous potential in the future for lawyers to become more knowledgeable about economics, because particularly in patent litigation, the numbers are big, as we've heard this morning. And most lawyers, and certainly most judges, are manifestly unfamiliar with basic economic concepts, terminology, modes of analysis, yet you're called upon to evaluate cases where the monetary sums are enormous. So I think in the future, part of legal education will be to bring these two cultures together and hopefully get a better outcome. So let me turn to Unilock for starters. Unilock is a very interesting case because it is one of the very, very few instances where a court actually makes a specific pronouncement about a damages methodology. That's something where courts historically, as far as I can tell, are extremely reluctant to say anything for reasons we can only speculate on. But as a factual matter, there is a very low bar for a lot of expert testimony. And when a couple of years ago, when Daubert and Kumho Tire, which were the two main decisions for admissibility of expert testimony, came along, I thought, this is great. This will really clean up Dodge. But no, it is, you have, as an expert, there's almost a chance of getting struck by lightning as of getting excluded under Daubert. It's an extraordinary event if an expert is excluded. So experience so far has shown that having a judge conduct a kind of trial before the trial is very unlikely. And you'll find, I think, as patent litigators, it's a great challenge to get a judge to rule in your summary judgment motion before trial, let alone hand down a Daubert ruling. So that, but that makes Unilock all the more remarkable because the central message in Unilock is specifically about a damages methodology. As a case, Unilock is part of a string of several recent cases that do not define by any means how you should do damages, but it starts to provide some more structure and some more discipline on the whole process. And as listening to the comments this morning, I'm viewing these cases, these damages cases that I'll itemize in a second, kind of as the back-end equivalent, because you only get to damages when the trial's over, basically. It's a way, these decisions are clearing up damages in the same way that on the front end, reforms at the PTO may rectify a lot of these problems at the source. But when you have a trial where often it's because of problems with the patent in the first place, there is an issue about how do you then value this thing. And the Microsoft cases that were described are kind of typical, where the defendant will say, $3 million, $5 million, and the plaintiff says $500 million. and the jury somehow has to make sense out of all of this. Uniloc came down actually explicitly saying that as a methodology, the 25% rule is no longer admissible under Daubert. So this is a one-of-a-kind decision. That the message right now is that if you're an expert and you use the 25% rule, at least in federal court, it's almost automatically you're going to be Dauberted. So I don't expect to see it in the future. The other cases that kind of start to define where we are in damages are, I think, cases like grain processing, crystal semiconductor, Lucent, and I hope at some point you get familiar with these cases because they really inform the type of economic thinking that has to be relevant for damages work. I don't know how significant they are in terms of legal analysis, but certainly for grafting economic concepts into the type of work you're going to have to do as a practical matter, they're really fundamental. So let me just repeat what the 25%, the classic 25% rule is, because that is Bob Goldscheider's contribution, and I don't think he necessarily made it explicit to you in his comments here. The 25% rule in his what he calls the classic formulation is one in which, as a starting point, the royalty for a reasonable royalty determination, the starting point for the royalty is 25% of the potential licensee's profits, but that starting point is then adjusted up or down according to the facts of the case to get to some final number. So that classic formulation is to be contrasted with what Bob calls the 25% rule of thumb, which is a 25% share without any adjustment at all. So the classic formulation is 25% then with some plus or minus factor that's case specific. Let me say, as far as I can tell, and I've read every 25% case that I can find, I don't think there's a single example of a case where the 25% rule of thumb was ever used. Every case out there has 25% and then the expert moving up or down based on some set of criteria. So what Uniloc was explicitly condemning is, in fact, the classic rule, because every case out there, including Uniloc, was one in which an expert introduced adjustment factors based on Georgia-Pacific and other notions of what a royalty might depend on. And let me come back to that in a little bit, but I have some other points I'd like to make. What do we need to do in a typical patent infringement case? The task is to come up with a value typically of a single patent that I would call a naked patent. It's not combined with any other patent. It's not combined with additional features like territorial exclusivity or licensing exclusivity. It's not bundled with other types of intellectual property. The task in a typical patent infringement case is to value the bare patent. How do you do that? Well, everybody recognizes that's kind of hard. The facts that are available in a lawsuit typically are limited, a little squishy. There's always some ambiguity. So courts historically have taken a pretty open-minded view as to what would constitute a damages methodology, as long as whatever the party had to offer was tied in some way to some recognizable facts in the case. The courts had very broad discretion to allow testimony Very rarely was testimony excluded. And of course, the Georgia-Pacific factors have become kind of enshrined as the altar where everybody bows in their case. And you'll see in the typical decision, I can certainly tell you in the typical expert report, the 15 factors are listed almost by rote, and they're evaluated typically in 4 or 5 sentences as though that was some kind of analysis. And it's all kind of a very, that's the way it's done. And the 25% rule historically was just another methodology along with other methodologies that were in play. And that was the situation for a good 30 or 40 years, going back into the early 1970s. Now, what we heard this morning I thought was quite interesting. With the large patent portfolios that were acquired by Google with Nortel and so forth, actually, if you did the arithmetic and took the prices paid for those portfolios and divided through by the number of patents, the number I got was roughly $700,000 per patent. And if patent infringement litigation was resulting in damages awards of $700,000, or was it, Suzanne, was it you who reported $4 million as the median award? I think if the numbers were in that neighborhood, whether they were arrived at by the 25% rule or any other methodology, then I think the courts would be prepared to accept it, recognizing that nothing is perfect and you have to reach some kind of answer. What happened in the last couple of years were a series of cases where the damages awards were absolutely off the charts huge. And for patents which everybody really had questions about. For example, the date picker patent or the I4I technology, you name it. Cases where suddenly the damages awards, and they tended to be for software, were for hundreds of millions of dollars. And in the case of Unilock, and in the case of I4I, the methodology in each case was the 25% rule with adjustments. So it was the classic 25% rule. And the Federal Circuit has some very activist judges right now, Judge Rader in particular, who have, I think, made it a personal mission to try to rein in damages methodologies which are leading to results that are perceived to be just unreasonable and unacceptable. So specifically, the Unilock decision said the problem with this methodology is that the 25%, even as a starting point, was actually not tied to any facts in the case. It's a bare number, and the decision said that you can't do that. You have to have a damages methodology that is tied to something in the case. And the fact that it might be adjusted afterwards is of no moment, because starting from what I would call almost a random starting point, although a high one, and with subsequent adjustments, is not good enough, especially when the rationale for the adjustments off the starting point are not spelled out anywhere. It's the expert's subjective sense of what the right number is. And that was, that door was closed by Unilock. I would say that the court got it right for a couple of reasons. Let me just briefly describe some of the key issues there. One is, suppose it was the case that you did the 25% rule in an ideal way, where you started with your 25% number and then you adjusted it up or down and then you got to the right number. That really implies that you know what the right number is, right? Because if you're starting from 25% over here, but then you're ending up over there and you know that that's the right stopping place, then you must know what the right number is. So why not just go there directly? The 25% starting point is a detour. You may as well say, I'll start at 0 and build it up to the right number. It doesn't really add anything. If you have the proper economic analysis applied to the facts of the case, you should get to the right answer. And in fact, in its own terms, the 25% rule actually doesn't help you. The adjustment maybe helps you, but then the adjustment is an unidentified procedure, so it doesn't stand up as a methodology. Point number one. Point number two, where did the 25% rule come from? Well, there's a logical problem because, as Bob just described, it emerged from a series of licenses that he negotiated at one time for Philco. But look at what those licenses contained. Bob has described this procedure in a number of articles where it was for, the Philco license was for a portfolio of patents. It included all sorts of other intellectual property, such as copyrights and all sorts of technology transfer agreements, so that the 5% royalty in that license was not for a single naked patent, which is what you typically have to do in a real case. The 5% covered a whole gamut of intellectual property, including a portfolio of patents. So in the end, even taking the Philco example as a template, it doesn't actually give you any information about the actual standalone value of even the portfolio of patents, because there's other stuff included, and it certainly doesn't tell you anything about the value of a single patent in that portfolio. So it seems to me that from the get-go, the 25% rule had the sole virtue of simplicity, because anybody can do the math. But the problem is, what are you really doing? And I think that it took until Unilock to come to the realization that you actually were not computing a number that was economically meaningful. It was an algebraic calculation, but it wasn't economically meaningful. And that's the standard that you have to meet in a case that makes any sense. There's another conceptual issue with the 25% rule that actually was not discussed anywhere in Unilock or any place else in the literature, to my surprise. So I wrote about it last year and again in an article that came out in the very fine Duke Law and Technology Journal last Saturday, which is, and this is, I think, very important for you lawyers out there who maybe don't have any economics or finance or accounting training. It's the following. 25% of profits sounds good, but what are profits? That turns out to be a huge question, because Mr. Goldscheider has written many times that it should be 25% of operating profits. Operating profits means you take the revenues, you have some product, you sell it, you deduct the direct cost of production, and then you subtract off all sorts of corporate overheads, and you get down to operating profits. I can tell you from reviewing all the cases that only rarely has the 25% rule actually been applied that way. I think in many or most of the cases, the plaintiffs, and I can tell you that only the 25% rule is, I think, almost only used by plaintiffs. The calculation is applied to gross margins. Gross margin is revenue minus the direct cost of production, and you stop there. That makes a huge difference, because in a case like I4I, which raises many interesting features, but I'll just focus on the profit issue for now. I4I was a $200 million judgment against Microsoft using the 25% rule with a plus or minus factor that was negligible. So it basically was it stayed at 25%. And it was applied to Microsoft's gross margin, which was described in one of the earlier presentations as about 76 or 77% of revenue. And that's how they got the $200 million. If you applied it to Microsoft's operating profit, as Mr. Goldscheider says is the right way to do it, that $200 million would have gone to south of $100 million for that reason alone. So there's suddenly a 50% swing or more just on the choice of profits that you choose to make. And I frankly was astonished that Microsoft did not pick that up, because it's a home run, but they didn't do it. And there are many other economically interesting features of the I4I analysis that, again, simply were not identified at trial, to Microsoft's misfortune. And I described some of those in an article I have in the AIPLA Quarterly Journal last May. You might want to take a look at. It's all laid out in 3 or 4 paragraphs. Unfortunately, it's that simple. Let me start to aim at wrapping up my introductory comments here. Lucent, so the big cases that people are talking about now in damages are Unilock and Lucent. So Unilock took care of the 25% rule. Lucent is really aimed at a damages approach that's far more common, which is simply trying to find comparable licenses and taking the rate from that license and saying, that's our rate. So if you look at Lucent, it's typical for dozens of cases of that nature where the expert will say, here are 10 licenses, the rates go from here to there, and I'll pick this rate. And as was described earlier, the problem in Lucent is that the licenses that were picked seemed so far afield from the actual technology at issue that it just didn't make any sense. So Lucent has set actually an extremely high standard now for proving comparability of benchmark licenses. It may even be an unattainable standard. Some of the decisions following Lucent have been so severe that it's created a gigantic issue in patent damages cases, because easy shortcut methodologies like the 25% rule are out. The normal strategy of finding some comparable licenses is almost out also, because it's very hard to find a license that's truly comparable to the particular technology that's at issue in a particular case. And it's very unclear at this point where that's all going to go. I think actually that there is a strain of analysis that will come to the fore. It's been latent for a long time, but I think it's going to come back, which is what used to be called the analytical method, which actually, in its modern form, did start with the Georgia-Pacific decision, where the judge, who is extremely capable, reviewed an enormous record. That case went on for 13 years. The judge reviewed an enormous amount of information, and he looked actually at the detailed operational business performance of the infringer, and came up with a royalty rate that he said fairly reflected what a fact-based hypothetical negotiation would have led to. And that was a very good approach. Unfortunately, he got it wrong, because one of the great ironies of Georgia-Pacific is that the decision that gave us the Georgia-Pacific factors actually was overturned on appeal. Or the judgment was set aside on appeal, and the appellate court provided its own number. But the idea was good, which is that you should be grounded in the facts of the case. And that there have been a string of cases since, like TWM Vidura, where the emphasis in each time is actually using some kind of financial modeling based in the case, and try to reconstruct a hypothetical negotiation in a plausible way, recognizing that it's a very imperfect construct, but it might be the only one that will really work, that has the best chance of working in practice. So let me say that at this point that there are a couple of principles that should be borne in mind when you do this market reconstruction of imagining how a negotiation should have taken place, although it was one that actually never did take place. And some of these points have been discussed earlier today. One is, in trying to set at least some basic parameters on how that negotiation should play out, you have to keep in mind what's the infringer's next best alternative. Because if somebody could do something else that would cost them $1 more, to be very reductionist about it, it's not plausible they would pay more than $1 for your technology, because they would do the alternative. So it's very important to identify what's the next best alternative that the infringer has. Secondly, a mental experiment that's often very helpful, especially for some of these cases involving patents of an evidently very minor nature, like the date picker. Ask yourself, and frequently there's a way to get there, either through econometric modeling or through competent survey evidence. What's the value of the project? What's the value of the product without the infringing feature? So if Outlook sold for $97 or whatever the price was, you could potentially get valuation of Outlook without the feature, and I would be not surprised if Outlook, if the infringing version of Outlook was sold for $97, and if the version without the date picker is sold for $96.50. But presumably facts could be brought to bear to get at that kind of valuation, because conceptually that's a way of isolating the value of the specific technology at issue, which is what you want to do. Third, there are technologies that are quite valuable, and this is not, what I'm laying out here is not some plaintiff-oriented or defendant-oriented technology. These are just general principles that I think should apply in every case. When you have a technology that's particularly valuable, so that the patent holder is in a very strong negotiating position, they could very well extract a substantial royalty. But there has to be a limit on it. And I've written on a couple of occasions that the upper bound, even if there is no obvious alternative for the infringer, the upper bound on the royalty should be one where the patent holder at least makes their cost of capital. Because if the rate was any higher, you're basically telling the infringer that the business is not worth pursuing, and that's inconsistent with the notion of a hypothetical negotiation with a willing buyer and a willing seller. So the cost of capital is one of those things that again can be determined empirically, and it helps put some discipline on the whole process. And I guess the last thing I would mention in this regard, especially to a group of lawyers, is that granted that there is a significant challenge in constructing a plausible hypothetical negotiation, one way you have to exploit as litigation strategy is getting the business plans of the infringer at the time of the infringer, because at the time of the infringement, because somebody does not use an infringing technology in a vacuum. It's part, presumably, of a planned product launch, which has been studied by the business people in the organization, and there's a whole array, presumably, of financial analyses to determine the expected profitability of the technology once it gets to market. So you're in fact not, you're not studying something that's existing in a total information vacuum. There typically should be a lot of documentation about the expected profitability from the point of view of the infringer. And it would be documents that would be created in the normal course and would be extremely relevant, valuable information to consider. And I'm totally certain would be admissible in any court. And those are my introductory comments, and I look forward to hearing what the rest of the panel has to say. Thank you.
So, Mr. Goldschneider, do you want to make a few comments, and then we'll hear from Dr. Liu?
Are you finished for the time being?
For the time being, yeah.
Okay. Please don't go out and have intermission because we're thinking football this weekend. And hold your seats, and I'll try to be brief because I'm anxious to hear Jack Blue myself. But firstly, the initial remark that Roy Epstein, who is not now my good friend, but who I hope will become my good friend in time, was congratulating himself on being an economist and downgrading the lawyers. Be it known that I'm a graduate of Columbia, class of 1951, with distinction in economics, magna cum laude, before I went to Harvard Law School, where Mr. Golden held forth. But I was a classmate at Harvard of somebody by the name of Derek Bach. We were 2 of 7 in the class who got a Fulbright at the end of our time, and I'm in touch with my friend Andy Kaufman, who is going to see that the 25% rule is properly publicized in Harvard literature, and alumni literature and stuff like that. I don't want to belabor this, but the 25% rule does not just apply to patents. The original situation was a bundle of patents, trademarks, trade secrets, copyrights, all those things. It's perfectly applicable to that, or just a trademark license itself, or copyright license. It's that flexible. It has been successfully used and is now sleeping in the vault of many hundreds of existing license agreements. And that's happening because it works. There has been no advertising. We're not advertising lists like Ford cars or cigarettes or even sexy movies. There's no advertising at all for this, but yet it has become ubiquitous. Why? Because it works. And why does it work? Because it's based on human nature in some ways. I knew there was some value in that gave the licensor only about 25%. I was very surprised that the inventor of all these wonderful technologies just got a minority interest in the whole thing. But then we began to measure that against the risks, the investments, the skills in going up against competition that the licensee had. And sure, the licensee was really contributing the major portion to the ultimate profitability. It made sense, but that was a surprise to me. And so my recommendation is that you carefully read the new article that I wrote, on which I spent, it went through 3 writings. I write pretty quickly, but this one didn't go quickly because I have a lot of things that are mixed together in it. There's sort of something funny at the end, which I'll get to just before I end my remarks now, but I just want to take apart a statement that you made, Roy, in your recent agreement that was a pretty tough one, and it made me look pretty unscrupulous. And since I'm scrupulous, I want to put together the sentence, if I can find my glasses. I think I now have found them. You make a statement in your paper on page, I guess it's, oh, no, I don't know what it is. It's published by the Duke Law and Technology Review. And it says, one main proponent of the rule, that's the 25% rule, claims the Federal Circuit was, quotes, misled, close quotes, and that its ruling is, quotes, dangerous and unnecessary, unquote. Now, he was paraphrasing some things from my article, which was published in the Duke Journal earlier this year, which was its first publication, and then it was published in Les Nouvelles, in which I made a number of statements in different paragraphs that got shriveled up into one single sentence by the magic of Dr. Epstein's creativity. And let me read the various pieces to that puzzle. I talked about group being misled. I feel like the governor of Texas in his debate with Newt Gingrich. No, I can't find it anyway. But I'm not withdrawing from the campaign, in case you're
And it's not that bad.
and I'm not a conservative, I might add. I apologize for the delay. We're getting close. Okay. This is the reprint from Les Nouvelles, by the way. I said, in the recent Federal Circuit decision, if the recent Federal Circuit decision means to challenge the classic 25% rule, whose demise the Federal Circuit claims to be demanded by Daubert's progeny, then with the strike of the pen, the Federal Circuit has thrown into jeopardy hundreds of relationships applying the, quotes, reasonable royalty, close quote, standard of 35 U.S.C. 284, thereby confusing those transacting in the marketplace. In other words, lots of people have done this and have lived with it and have not raised any problems with it. If the Federal Circuit intended, if such results in unilock, then those involved in the art of IP licensing should be seriously concerned. I use the word art all the time in connection with licensing, and that's the title of that thick book you see here sitting on the desk over there. Then I go on, I believe the Federal Circuit has been misled about the realities of the classic 25% rule. That's where we get the magic word, misled, that Roy used. I believe the Federal Circuit has been misled about the realities of the classic 25% rule, which is quite distinguishable from the Federal Circuit described in unilock as the 25% rule of thumb. Therefore, I hope that the substance of this article will be taken into account by parties who can still petition for certiorari. That's on one page. Now we go a few pages further, and I say that this was when I wrote the article. After many years of having lived with the rule, I said, 6 years later, that was last year, as I draft this article, my beliefs remain the same, that the rule is a sensitive methodology whose widespread acceptance has been merited and guaranteed its longevity in the licensing profession. In my opinion, it will still, regardless of how courts view the admissibility of the classic 25% rule in litigation, continue to guide the outcome of thousands of IP licensing transactions, not involving litigation, throughout the world. Businessmen love this rule. They don't understand calculus. They don't understand a lot of things that are going on, but they know what it's like to negotiate the purchase or sale of items, whether they be real items or an invention. And that's the reason they're so comfortable with it. They sit down with it, and they know whether or not something should be changed. And by the way, if there's real risk, many times in these negotiations, they say, a year from now, we'll look at the numbers. We're expecting you're going to make this sort of result out of this. We don't know how the market's going to react. We don't know how some of our competitors may react. We don't know how good our advertising is going to be. Let's look at it again, and we'll adjust it. That's business. And the 25% rule, the classic rule, is business because it's based on facts. What we've got to do now is to improve our fact-gathering capability, and that's one of the reasons I'm looking to this smiling fellow sitting at the end of the dais, because I believe he can supplement my limited skills as a 20th century lawyer. Let me go on, because I still haven't gotten to all the words that were quoted. It will still, regardless of, and I'm saying that regardless of what the courts are saying, businessmen are still going to use the 25% rule. So let's get used to that reality and see to it that it's adjusted to be as good and accurate as it possibly can be. I said, however, the unilock ruling could disrupt the consistency, the consistency between hypothetical negotiations in court and actual negotiations as they occur in the real world. This development is both dangerous and unnecessary. That's where my magic words, dangerous and unnecessary, in Roy's text, let me go back to read it. One main proponent of the rule claims the Federal Circuit was misled. Well, he was misled, that's several pages back, and that the ruling is dangerous and unnecessary. We don't have to have a different rule for the marketplace and a different rule for the courtroom, because that adjustment can be made. I'm almost finished. I hope that if you are interested in the subject, read both of our articles very, very carefully. We're not finished, because it's certainly of great interest to both of us. We both want to get to an end whereby this is going to be recognized in some universal way. By the way, I can tell you a little anecdote, and that is that people have talked about the Daubert decision as being responsible for the flurry of activity questioning the use of expertise in backing up opinions on technology evaluation. Well, it turns out that the mother of the commentaries about the Daubert rule is also the mother of my son-in-law, Professor Berger, who is dearly remembered, who died unfortunately 3 months before Uniloc came out, and who was the first clerk of Judge Weinberg in Brooklyn. And together with Weinberg, they have Weinberg and Berger, which is the leading treatise in the rule of evidence, or the law of evidence. I asked her as we were drying dishes one day, after having eaten an excellent dinner at my daughter and her son's house, Margaret, are you going to put me out of business with your decision in Daubert? And she said, Bob, I know how hard you work. I know the amount of detail you go into in reaching your decisions. You don't have to worry about that. But there are some people who could worry about that. And if you want to see a real example of how I've used the 25% rule, read carefully the first article, which describes my participation in the biggest lawsuit I've been in, Hughes Aircraft versus United States, having to do with the Williams patent, which had to do with the adjustment of the position of a space satellite. I visited 5 different installations of the US government where they were building and testing satellites. I spoke to almost all the scientists who were working on the situation. I was examined on the stand for 2.5 days, and I've made the testimony available. The Department of Justice were good enough to give me my entire transcript from 10 years ago. You would see the detail that we went into to do that. All of the things which are expressly indicated in Uniloc were done by me years before any of this happened. And by the way, what was the baseline royalty percentage that I used in my testimony? Was it 25.75? No, it was 15.85. Because I always reserved the right to start at a different area than 25%. Now I think we would go be even more careful about choosing that, and that's discussed in my second article. But here is living evidence in a major case in which my testimony ended up, and everybody's talking about how expensive the 25% rule is, my testimony ended up as a royalty rate of 1% for the damages to be paid by the US government. I had 2 opponents in that case as experts. One, the recently retired Chief Patent Counsel of General Motors, one, the Chief Licensing Negotiator of NASA, who turned out later on to be a president one year of LES. They both said 15%. I said 1%. The case was then appealed, and it was appealed to the Court of Appeals for the Federal Circuit from the Court of Claims, and was argued on behalf of Hughes by the same gentleman who argued the impeachment of President Clinton. And the case was affirmed unanimously. So the 25% rule can work in the real world, in litigation. It can also work in the marketplace. We've got some work to do to make the two of them completely consistent and to work smoothly together. And I think if we do that, that will be a real accomplishment. And at the age of 82, I'm not simply going to play golf and relax I have a wonderful life, I'm happy to tell you, because I've succeeded in doing a lot of closed licenses and testified in court, and I've got a piece of some pumping licenses that are like oil wells in some way. But I'm going to work on this. I'm going to save this classic 25% rule, or my name ain't so-and-so. Let me just add one thought, and that is, I want you to know what my role has been, since this is Super Bowl weekend coming up, that my role, as I always told the lawyers when I would come into a case, because I'm still a lawyer myself, was as a place kicker on this team. I get my uniform does not get dirty, I don't get knocked over, and I can score a lot of points, so treat me well. Thank you very much.
Thank you. Dr. Liu, I think we have you next, and then let's still have some time for exchange.
This will become friends.
No problem.
Let's see, did you load yours already?
I think Richard did, right? Richard did?
Want a copy of this?
You know, it's no library.
It probably is, but no, it's yours.
Is it one of these?
Because it is, it's an art.
Thank you very much, and thank you for having me here. And I'm especially thankful for you guys to sit over here a late Friday afternoon. I'm sorry about that. See, you have had a lot of 25% rule. I don't know how many versions you already have. Okay, we had one from Professor Golden. He has 25% rule. Right? Has 4 components. One 25%. You got one from Bob, you got one from Roy, you know. See, to be honest with you, there is no the 25% rule. There's not. And so today what I'm going to talk about is, gosh, I don't know. Did I get it wrong?
It didn't work for me either. I used the buttons on the keyboard.
Okay,
Yeah,
it doesn't work for you. Oh, okay.
Yeah, you could just use this. This should work.
I can do this?
Yeah.
Okay, cool. Okay. So my presentation will cover 3 parts. First of all, I will give my understanding of the 25% rule. So one more version, okay? And then the most important question is actually how to apply it. And, you know, at the end of the presentation, I will give you some empirical evidence. Now, I don't want to review like, calculus 101 with you, but I do have some mathematical stuff. Okay, Professor Golden, who is the first one criticized this model, and I completely agree with Professor Golden, is right. The model looks like this, cannot be used as a benchmark royalty rate. It cannot. It should not be used as a benchmark, but it is a very neat model. It has some very great ideas. It basically says, okay, royalty rate, how do you decide the royalty rate? It basically depends on 2 things, patent strength and the negotiating power of the teams. I like the idea, although I disagree with them to use this thing as a benchmark royalty rate. So for this reason, I expand this model and I generalize it. Sorry about that. Okay. So what I'm saying is, okay, the strength of the patents is basically like if the patent is valid and is found infringing. It's the probability, okay? The probability of the patent is valid. And the negotiating power is basically the chance, you will get 100% of the value. The most important thing is like the V over here is not the profit, operating profit, whatever profit. It's the marginal value the technology created, okay? It's an incremental value. The value is not a profit margin when we are talking about here, okay? It's essentially, that's what comes to that point, like, when you have so many measures, which one, what are you talking about? Okay, what I'm talking about is value, specifically the value the technology created, okay? What's that? I don't know, let's go. we will find out, okay? So the thing is, it's a more, all those factors, S1, 2 to I, and N1, 2 to J, are basically multivariate normal distributed, which means the mean that, that's zero. That mean. Okay, no, I'm sorry. So you apply tail expansion, and you got something there, and say, if you remember the basic statistical thing, okay, it is the mean, the probability distribution, the mean is all 0.5, right? So assume with me, the pattern strength and the negotiating power are independent. I know you guys won't disagree, because you always had a lawyer says, if you hire me, I can, make you a crappy pattern, I ain't crying. But it's not, let's say for now, let's see, that won't happen, okay? That won't happen equal. The pattern's strength and the negotiating power are completely independent. So in this case, we can apply tail expansion, and we got over here. So basically, what the formula basically say is the mean. When you have average strength of the patterns, you have average negotiation power, you got a 25% of the marginal value, okay? But if you are not, you have to adjust it. Like if you are SI, which means your strength is different, you have to adjust it. And if your negotiation power are different, you got to adjust it again. So, if you don't like the formula, let's get something. Okay, here is my theoretical model of the 25% rule. It's basically you split 25%, and then you adjust it based on the factors that determine the stuff. So you have 3 items over there, 25% is the same. The important thing is over here, okay, this is basically a statistical thing, okay? Like for each individual patent, when you value it, okay, 25%, and then you plus all the factors, adjust all those things. But if you have a large sample of it, like if you have like 1,000 or 100,000 sample of patents, and then you have their marginal value, the ratio of royalty to weight, the royalty to marginal value will converge at 25%. That's the statistical law. So it's like if you have a large sample, you put them together, you do the average, the mean, the second term and the third term, if you remember, it's going to be 0, right? It's going to be 0. So you do the average, only the first item going to be there. The second and the third will not be there. So, in other words, what I'm saying is this theoretical model of 25% rule is true statistically, and is true in plain English, and I think it remains true even in my exotic English. Okay. So I'll give some special scenarios over here. Like, when you have a ironclad pattern, the theta will be 1, right? And you basically split half. So that's what people say, okay, there is a 25% rule, and there is also a 50% rule. That's right. If you assume the pattern is very strong, is ironclad, your starting point is going to be 0.5 instead of 25%. But it's a very special case, right? The only, like in the early stage of hypothetical negotiation, you never know. So you always assume is a probabilistic pattern, like it's a pattern, we don't know how strong it is. All right? So, and the third scenario is a state and pattern strength and the equation both are 1. In this case, it's a very classical economic assumption, you can basically extract all of the profits from the S&C. So I want to bring this thing to the Unilock case. Okay, actually I agree with Dr. Epstein, and I agree with the Unilock ruling. It is true, 25% rule of thumb is a special case. You can see it. It's a special case in my formula too. It's only the first item. Okay, it's only the 25%. It's fundamental fraud. Yes, it is true too. Why? Because if you don't have all those adjustments, you don't consider all those factors that determine the patent strength and the negotiating power, of course you're wrong, right? The third one is only true if we are talking about you use 25% rule and then you apply to an average profit margin or to a purely, how should I say, an entire market value thing. Then the third statement is right. But if you can do it with the marginal value, if you can find the marginal value and quantify it, I would say maybe it's okay to use 25% as a starting point, as we should, because our first item is always 25%. And so the next thing is, what's the way, right? We don't know the way. We don't know the marginal value, right? The good news is like in sub-license case, when the licensor take the knowledge, take the patent, and then license it to somebody else. Every additional license the licensee get is going to be marginal. It's going to be marginal value. It's going to be perfect. Okay. So if you happen to deal with a sub-licensing, you have no problem to define and identify the weight thing. But the problem right now is the marginal value. If the licensee uses the technology to produce an iPhone or whatever, See, over here, the marginal thing, the incremental profit is notoriously hard to define. It's basically no way sometimes, to define. And so ideally, we want to say, okay, it's going to be cash flow generated over the years from now. It's going to be present value, okay? And the present value, if you know, like a finance 01, the closest thing to the value measure is EBITDA, which is adding before income tax and depreciation and amortization. That is the closest thing to the so-called value. So we use that. But we know that the problem is it's very hard to measure the marginal thing. Like if you are a plaintiff and the defendant won't let you to go through their, finance department to get rid of all other costs that not only identify the marginal profit and the marginal cost. They won't let you do that. You will have produce a long list that said, okay, I need this, and they will come back and say, no, it's too many. And eventually, I'm going this kind of process every day almost. Eventually, what you got is what you got. It's not gonna be the marginal thing. It's gonna be anything. So way is kind of harder to define, but we know theoretically what is the way. Right? So the adjustment is gonna be even hard, right? You see the S1, 2, 3, say, and the N1 to J thing, the factors that determine the patent strength and the negotiating power. We don't know what it is. There are so many factors. Okay? So right now the current practice is like, you got some technical experts to say this patent is good or bad, some stuff like that. And then you have, of course, Georgia Pacific 15 factors, okay? And the problem with GP 15 is when the plaintiff uses it, they say, I'm adjusting, okay? I'm doing like a very serious, kind of analysis, okay? And then when the defendant will say, well, it's a lip service, it's basically blah, 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 nothing. So the problem is, everybody knows, you need to make the adjustment, and you may know the direction, adjust up or down, right? Based on the Georgia Pacific factor. But the problem is you really don't know how much to adjust, right? When you adjust, like I could say, let's say Georgia Pacific factor 1 or 2 or 3, and then you review all the materials and yes, the royalty rate should adjust down. How much? I have been in this business 12 years. I never see somebody say adjusted down by percentage point. never see it. It's very hard to do it. Okay, see, what I am kind of advocating right now is, okay, let's forget about adjusting factor by factors. Let's just see some specific things has a premium discount. If you remember the basic finance theory, the equity valuation part, the Farmer French 3 factors, they have like, okay, there's a build-up model, is you have risk-free rate, and you have market premium, and you have size premium, and you have those kind of financial distress thing. So when finance people, I'm a financial analyst, by the way, when we financial analysts value the things, we always look at the risk premium. Okay, if we have the risk factors, you want to add or reduce, you want to add some premium, or you want to reduce something. Negative premium is discount. Okay, you want to add it or reduce. You know that. So over the years, over like 100 years, over the development of the financial valuation and the business valuation models, and we have all the data, and we can easily pick up, okay, size effect, okay, good, like 3%, okay, and then where you have like, financial distress risk, okay, 4%. You pick up all this model, and right now the treasury rate is like 3 or 4%, okay, then you value a business, okay, 3% plus 4, 10%. And then you have some other premium data together, okay, eventually you will say, this is like 20%. I think we need to do the same thing in the patent valuation. Okay, one thing we can do is, okay, we use a 25% split of the marginal value as a starting point, and then we somehow find the patent street premiums. Okay, that's a good patent. You would assume in the licensed market, a good patent should carry a premium, right? And the negotiation power premium, which means like, if you are in very strong financial situation, if you have a large patent portfolio, if you hire a good lawyer like some guys graduate from Duke Law School, and then you have a premium, right? So eventually you add this premium together, hopefully you will get something. So what I'm saying is like we borrow something from the traditional, is a very well established equity valuation method to build up something new. Instead of use generally talking about the GP 15 factors, adjust this, adjust that, and nobody knew how much to adjust, right? So what I'm saying is, maybe we should spend more time, spend more efforts in our business, in our profession to develop this kind of things. And this thing is going on. And for example, like there are a bunch of studies, like that actually, I did one in 2010, in the medical device industry, actually find like if the licensor is a university or federal lab or research institution, their loyalty rate is on average is 2 percentage points lower than the average loyalty rate. So there is a discount over there. And then you have claim premium from a UCLA professor, and like your patent have more claims. Typically, they have their loyalty typically are higher. And the exclusivity premium, and there are some study over there. And then the last one is technology readiness premium. Is like in the later stage of development. In the early stage, the loyalty are going to be lower, and in the later stage, if we move up, they're going to charge a higher loyalty rate. And we do have some evidence of that. These charts, I'm in the executive committee of the LES High-Tech Loyalty Survey, and I have their permission to use these slides. So in aerospace, the first bar chart is the aerospace. So in aerospace, you can see very clearly, okay? In prototype, it's 6.5%, and in the fully development, but not commercialized yet, it's 10, and in production, it's like 14, close to 14%, more than 14%. So there's evidence over there. There is technology readiness premium, and as the technology develops, in the later stage, they should have a premium. And the software too, you can see the software is very nice too. From R&D to prototype, blah, over up, every step, the loyalty is going to be different, and there is a premium on that. So when I talk about when I move to the empirical studies, let me just remind you these charts, okay? This, as I said, the sub-license royalty revenue is exactly what we call marginal value. So one of my friends, he just published an article. This is the first one in our industry, okay? Whoever take a systematic research at sub-license agreements, and he has a huge database, and this is his conclusion, okay? Which means it's exactly 25%. It's marginal value, it's sub-license revenue. Each additional sub-license he got is marginal. So the value is marginal, and 25% is there. So this is very strong evidence, but you see the bottom, okay? Read the fine prints, and that's what Tom says. He's not a fan of 25% rule, and when he told me this, he actually said, I don't like it, but the evidence is here. So there is only one study published so far. The probability data is marginal, is this study. And I know the author, and I'm very kind of thankful they actually give me the data to do the analysis, okay? So this study basically, remember, okay, there are profit measure over here is marginal, okay? It's like a project level. It's a project, it's not like a company level, not a order, it's a per project, so it's marginal. So he said like an average probability of this thing is like a 65%. If you said like a, Dr. Epstein said, okay, if you simply apply 25%, that's what you got, 16.3. We have 61 transactions. Supposedly, if we use only 25% rule, it's going to be 16%. So I want to do some statistics. You remember I said before, if you, on average, if the actual rates minus 25%, it should be 0. But it's not, right? It's not. The T is 2.38, which means 25% rule of thumb systematically underestimate royalty rate by 3%. So the 25% rule of thumb doesn't work. It's true. That's what his title says. The title of the company, there's no place for 25% rule. Yes, there's no place. But we talked about technology readiness premium. So the 61 transactions in his study are from 6 different stages of the development, okay? So if you took all those 61 royalty rates and do a dummy variable regression, and you find a first 3 patents has a premium of 11%. Of course, you will ask me where is it for phase 2, 3, and others. For his data set, I couldn't find any premium except for phase 3. We do have an 11% premium. And remember what I said, when you have a premium, you add them back to the 25% rule. So if you add this thing, the mean is 0, which means if you made the appropriate adjustment based on the premium or based on anything else, the 25% rule still work. I mean, but you have to do this kind of adjustment to make sure you have adjusted. Otherwise, as I said, so it doesn't work. But over here, it actually works. All right, that's my comment. Thank you.
Thank you, Dr. Liu. I don't know, Danielle, how you want to work this. It's 5:05 now, so should we have a few questions from the audience? Dr. Epstein, do you want to respond to any of the comments that have been made? Maybe Dr. Epstein should respond, and then we can perhaps have a few questions from the audience.
Well, thank you. I'll only take 30 seconds. One is, Bob is a very charming individual, and I'm very glad to have met him today. But all I would say in response is that I think he verified that I cited him accurately, and the 25% rule, as it might be used in an actual business negotiation, is a totally separate matter from determining a reasonable negotiation once something gets to the litigation stage. It's really two entirely separate questions. And I'm not taking any position on how business people in their actual face-to-face negotiations would use the rule. I'm just saying as a matter of, at this point, of law, but also of the practicalities of the litigation process, that it's just not a workable vehicle anymore.
I have nothing to add at this point. I think I've given you enough of my thinking, and let sleeping dogs lie. Read the article. Maybe we'll write one together, as a matter of fact.
And Dr. Liu, just to be clear, you were talking about it as in terms of the ex-ante negotiations, not in terms of what.
I'm sorry, could you?
I was talking to Dr. Liu.
Oh, yeah.
Your presentation was discussing it in the context of why it might be used ex-ante in negotiations.
Yes.
As a rule of thumb.
Yeah. Yeah.
Yeah.
If I could just ask quickly, so the reason why in the last slide you focused in on the phase 3 was you assumed that that's the point at which the hypothetical negotiation at the point of infringement would begin?
No, actually, in my model, I have all the 6 stages over there.
Yes.
But the regression model only indicate like the phase 3 has a problem. The all other phases have no problem. Okay.
Is there any evidence from the negotiations to suggest the actual negotiations, to suggest whether or not the negotiators may have been influenced by the existence of the 25% rule of thumb in the litigation process?
I don't.
Because that would be a concern, right?
Yeah.
That, if the reason why it was resulting in
yeah.
25% is because that's the benchmark
Yeah.
set by the institutions as
No,
lawyers that they are used to.
I would say 25% rule from the beginning is like a statistical rule. It's not like an individual thing. Like when you have individual patents, like if you are an IC over there and you work with the license so with the license C, if you want to start with 25% rule, and you have to do all those adjustments. That's basically what I'm saying. It's if you put all those agreements together, all the licenses together, it's really, I think, it's pretty much, statistically, I think 25% rule is there. I'm not saying you use it in each of, like a negotiation, but at the end of the day, 50 times 50, that's in our human, basically, like our knowledge. Right? If you don't have anything, you go with the middle. You don't have anything, go with the middle. So eventually, put all those agreements together, it's become 0.5 times 0.5. So that's how the 25% rule, what I interpreted. So.
Other questions?
I would add one point I've been thinking about. The most successful licensing program worldwide that I know about is something that was done by Stanford University, and it was put together by their director of licensing, a guy by the name of Niels Reimers, who's an old and close friend of mine, now retired. The program involved the basic patents for biotech research by 2 professors at San Francisco University. Well, one was Stanford, one was San Francisco. The licensees paid a relatively modest, but nevertheless, it turned out very appropriate, lump sum royalties for the rights to use these patents. And over $325 million was collected by the universities as royalties to some 275 different licensees. Not a single litigation in that matter at all. Now, this was not something which sounds like the 25% rule, but Niels knew it very well. And he took the kind of mentality you take into a negotiation here, saying, the word is altruism. We think of the other side as well. We want a deal to live. We want it to be a mutually successful deal, and we want it to have good results for the marketplace or the society or whatever it may be. And that sensitivity went into the structure of that license strategy, which worked like a charm. Not a single litigation, and everybody paid up a fairly considerable amount of money, but a very reasonable one, and tending to be a little bit on the low side. But the 25% rule was a shadow at the back of the stage. And that's one of the reasons why I think it's so valuable. It's based on reasoning. And it's also an art. It's not something that you do mechanically. You say, oh yeah, I'm going to sit down, okay, you're 25, you're 75, that's it, let's go home. That's the rule of thumb. It's something which says, how much are you bringing? What's the quality of what you're doing? What is the highest rate that the royalty should be, because what the nearest non-infringing alternative is? The Georgia-Pacific factors, I say in my article, my second article, are really poorly understood. I'm sure that this expert for Unilock really didn't understand it at all. He tried to dodge the whole thing. He said, well, I did looked at it, and they looked as if it balanced out, and so I just forgot about it. That's all he said, and the judge did not give any details. Do you know that what the first, does anybody tell me what the first Georgia-Pacific rule is? Very simple. I'll read it so I don't misquote it at all. It's simply stare decisis. And it's ruled by a U.S. Supreme Court case in the 19th century called Rule versus Westcott. It is the royalties received by the patentee for the licensing of the patent in suit, proving or tending to prove an established royalty. If you find out that this licensor has licensed this patent several times for a certain rate, and it has an established royalty, ball game's over, fellas. That's the royalty rate. It's an established royalty as a matter of law. And the second one, it gets close to it. So we're talking about basic law here. We're not talking about mumbo jumbo in Georgia-Pacific. That's one of the reasons it's so successful. The rates paid by the licensee for the use of other patents comparable to the patent in suit. Well, this judgment's got to go into that. Are these patents comparable? Is the market the same? So it's not a clear shot, but it is something which is understandable and has rationality to it. And if you read some of my writings, I have a detailed analysis of all of the 15 chapters. I don't like number 12, by the way, because that's the portion of the profit or the selling price that may be customary in the particular business or comparable businesses to allow for the use of the invention or analogous inventions. Is there a university royalty rate? That's too general for my taste. And I very often criticize this, except there was one case where we came down, we did use it, but I'm not going to waste your time with it. But the point is that these are weapons that are part of the 25% rule, because the 13th factor really is the rule, and now I'm sure that he had that in front of him when he drafted that thing. But we're talking about creativity here. If you're correct in doing it, and the royalty is really reasonable, be it in court or wherever it's going to be, it will be of the good things. But the 25% rule doesn't do anything wrong. It doesn't ruin your lungs like cigarettes do. It doesn't get you fat like overly caloric food can do. It's just something which does good in the world. Why some of these guys, and he's one of them, but he's one of the nicest ones, want to see this thing die, want to jump on it. Oh, God, we're rid of the 25% rule. No more of that nonsense. It's just like a fog coming into the house and going to blot out everything. Not so. It's an innocent, nice rule which grew up in lovely Switzerland. At least that's where I saw it. But this is a very humanistic thing which is happening in the law, which is wonderful. And there's a last chapter in my long career, and it's over 50 years. I'm enjoying it very much, and I thank you for your presence, and I'm sure that my fellow members on the panel feel the same way.
Well, thank you very much, all of you, for staying till the end, and I want to really thank our panel as well for a vigorous debate. And I think Daniela will have announcements about refreshments or.
Yes. Yeah. Thank you.
Produced by Duke University. Online at duke.edu.